Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us, and thank you, Therapist You Know, for gifting 10 memberships. That is awesome. Thank you. Thank you so much for that. Really appreciate that. So, thank you guys for joining us for Florida versus Donna Adelson. She has a hearing coming up today at 2:30 Eastern. But in the meantime, we're going to backtrack a little bit because we didn't cover three things happened. First was she got moved because of alleged assault. So let's go ahead and check that out first and foremost. Let's see here. So first of all, we're going to review that she got moved.
We confirm
because of alleged assault.
As a precaution, Adelson is...
Stop. Hold on. Okay, here we go.
Was moved into protective custody at the Leon County Jail as a precaution. Adelson is there awaiting trial in the murder of her former son-in-law, Dan Markel. According to the Leon County Sheriff's Office, Adelson claims another inmate grabbed her arm back in December and tried to extort her. LCSO says Adelson reported the interaction this week, but would not give any more information.
All right, so that was that was pretty quick. All right. Okay, here's a bond hearing. This one is from February 11th. So this was just about a month or so ago, 6 weeks or so. So let's check this one out.
This is 2024 CF 33.
All right, so this is from February 11th. This is a bond hearing. Let me just put that here.
It's just keep it on. It's relatable. Yeah, it's on. It's just nobody's on it.
Go ahead.
That's not my clock, Judge. Todd Pete, my case 2022 CF 336. We actually went to FSU Strozier Library yesterday, Judge. They're working on getting us some more documentation. We have filed a Brady demand. I think we have it set for a hearing, I believe, with your report. So I would ask that we would set this for that same day of that hearing, Judge.
What's that name again?
P-E-E-A-K.
That'll be 226. Be heard at the same time as the motion.
That'd be fine, Judge.
Yeah, 226.
Yes, motion hearings on 226.
The next one is James Rackley, 2024 CF 2477. We are negotiating with the prosecutor, Mr. Hughes, about a resolution. If we could have 30 days, Judge.
Mr. Fuchs, anything to add?
No, Your Honor, he's asking me to be more reasonable, and I asked for reasonable reasons to be more reasonable.
Yeah, we're working on more reasons, making more reasons. I'm saving for you, Your Honor.
325 at 2:30.
Dominic Rondinelli, 2024 CF 2769. We're trying to get more reasonable again with Mr. Fuchs. And, but I think we're working on a resolution. 3:25, is that the next one, Judge?
That is 3:25 at 2:30.
And the last one, Judge, I'm covering for Mr. Davis is 2024 CF 3341. State by prosecutor, Mr. Fernandez is here. I think they want to set it for April. Case manager.
Mr. Fernandez,
That's fine, Judge. We're just starting discovery right now. No objection.
4:15 at 2:30.
Thank you, Judge.
What's the name again?
Rajiv Shah, S-H-A-H, man.
And
4:15 at 2:30. Yeah, there's no room. There's no room. That's right. Ms. Adelson, I'm going to send you a prompt to unmute on your side. Did you get the prompt? I see your lips moving, but we cannot hear you. One moment. I'll send it again. Yes, he needs to get set.
Okay.
All
Can you hear us, Your Honor?
I can hear you clearly. Let's go ahead and address Donna Adelson, 2023 CF 3226. Gentlemen?
Good afternoon, Your Honor. Joshua Zeman on behalf of Ms. Adelson.
Jackie Fulford on behalf of Ms. Adelson.
There are a couple of things that we wanted to address initially. The state had previously perpetuated the deposition testimony of Dr. Clark, the former medical examiner. That was done by prior defense counsel. We've reviewed the material. There was one portion at the end that we had requested that they edit out, but we would stipulate that would be appropriate to present to the jury during the trial in our case. We've spoken with Ms. Adelson about that as well, and even though we were not counsel at that, defense counsel didn't ask any questions, and that would have been our strategy as well.
Very well. You may continue.
We are also stipulating to the foundation of the extraction of Wendi Adelson's cell phone that was conducted by Marcia Rodriguez, who will be out of the country at the time of the trial, so that they don't need to present her testimony in order to introduce the contents through other witnesses. We did want to inquire with Your Honor about the status of the in-camera examination of prior investigator.
With that, Lynn, has a date already been set for that?
I don't think so. Did we didn't set a date yet.
I provided his cell phone number.
This would just be me meeting with him. It's not a motion.
Yeah, no.
Okay.
I'll follow up on that.
We do have some issues with regard to discovery and prior case management. Your Honor had indicated that based on the conflict that existed in prior counsel you would understand if we were going to redepose some of the witnesses that had previously been deposed by prior counsel. There are three such.
Hold on. I believe I said if you needed to raise the issue, you certainly could, but that
We'd like to
do
raise
not
the issue.
accept that as a blank permission to redepose.
We didn't, Judge. We
Okay,
didn't.
go ahead.
So we've been working to schedule depositions with the state, and for this morning, for the first time, we learned that they do object to us redeposing 3 of the state's witnesses. One would be Chris Corbett, the second would be Special Agent Patrick Sanford, and the third, Robert Adelson. Mr. Adelson is the son of Mrs. Adelson, of course. His deposition would not be lengthy, but we do need to redepose him. The depth of the conflict between Mr. Rashbaum representing Charlie Adelson and Donna Adelson is probably much deeper than the court understands, and to the extent you'd like to know further why we would like to depose these witnesses and that particular conflict, we'd like to be heard ex parte and in camera with Ms. Adelson present to provide some information to the court as well on some attorney-client privilege information.
All right. This is going to need to be memorialized to the extent that you can in a motion. As far as any hearing that would occur in camera, I will make a decision on that. But first, I actually need to read the basis of what you're seeking and why.
Now,
Thank you, Judge.
with respect to Mr. Corbett, Your Honor, we haven't even received Sergeant Corbett's completed revised presentation. That is what the defense intends to take his deposition concerning. We've been told that we will have that presentation by this discovery cutoff, and so we were actually going to have to file a motion to extend the discovery cutoff for purposes of taking his deposition. And that was tentatively scheduled for May 14th, being that that would give us approximately 2 weeks to review the revised presentation. That's the reason for Mr. Corbett's. That's not a conflict issue, but we can certainly memorialize that in a written motion if that's what Your Honor would prefer.
Just going back and looking at the dates and the different cutoffs. 4:30 is the discovery cutoff by order right now. Ms. Dugan, as to providing Sergeant Corbett's presentation, why is this going to be so lengthy?
He's just working on the cases that are in front of him right now, but he has assured me that he's going to be working on this presentation as soon as he possibly can. I don't know of any new information in the presentation than what's already been given to him. It's more of formatting and making it look better as opposed to anything substantive. And my memory, if it serves me correctly, is that prior defense counsel's deposition of him was done after the same, as far as them getting the copy of what we were going to use, as far as everything substantive we were possibly going to use is in there. But, you know, the final result might look better at trial and be formatted in a different way. But substantively, it was all there. We certainly, and we want to be reasonable. We do object to, as far as all of these witnesses, they sent us about 24 hours they need to depose several witnesses. We worked with them to get times that we are available, and we'll continue to do that. Some of the witnesses have never been deposed before. We obviously have no objection to that. Some of the witnesses have been deposed by prior counsel of other co-defendants. Looking at the rule 3.220, it says any cases, including ones with multiple co-defendants or even consolidated cases, no one should be deposed more than one time unless good cause is shown. If it's something that pertains to their client that's, new, we don't have any objection to that. But as far as just setting these people for hours and asking them a lot of the same information that's already been said in prior depots, we would object to asked and answered and not want those people to have to be deposed again. And then as far as the folks that they named, I think it was Agent Sanford and Corbett and Rob Adelson, that Donna Adelson's former counsel has deposed. As the court said, we would ask that good cause be shown. We're fine with that being ex parte and in camera. But we would ask to have that done, be able to weigh in on that from our side as well in those same situations. and object to them being deposed again. If there is some new information in Corbett's presentation as of April 30th that they didn't know about before, we would absolutely be fine with him being deposed on that information, but just not having to go back through what's already been said with, hours and hours of depots and prior testimony.
All right. What I am not fine with is moving this trial date if it does not need to take place. April 30th is the discovery cutoff. We're going to leave that in place for now. Everyone is to work accordingly up to the deadline. If it has to be extended, it will. But there's still 2.5 months to that point. Right?
Yes, sir.
We'll draft the motion, Judge.
Yes, sir. And, certainly, by way of a brief response, and I will be brief, the rule cited by the state contemplates that the co-defendants are all being tried at the same time or have all been arrested. It defies logic to believe that
these trials have been spaced out. They are not co-defendants that are linked by one information.
Thank you very much, Your Honor. Lastly, this morning I provided a proposed order to the court from the August 30th and September 6th motions in limine. I prepared those based on the transcripts that I had prepared of those hearings. I provided them to the state twice over the last month and had not gotten a final answer. Does Your Honor want me to submit the transcripts from those hearings?
You can do so. I'll review them. Ms. Dugan, as the proposed order, is the state objecting to it, or you don't have an opportunity to review it?
I did speak with Ms. Kaplan about that, and we reviewed it. We don't have any objection.
Very well. I'll still review the transcripts to ensure it is accurate, but trust but verify. Go ahead.
Yes, sir. There are some additional motions to suppress and a handful of motions to limine. I'm hoping to get the motions to suppress filed in the next week to 10 days so that those can be heard properly. The motions in limine, we're certainly going to try and get those filed early to mid-April so we can get those heard as well. I just wanted to let the court know that the motion to suppress that we filed last week is not the only one that's coming.
I believe the date that we were going to have for the pretrial motions, that was going to take place on Friday, May 16th. Obviously, more that can be heard prior to then will lessen the burden on that day, but anything that's still outstanding, that's the day it's going to be heard before we move into trial posture.
Yes, sir. Certainly with the scope and breadth of the motions that we are working on, we'll try and get those on your calendar much sooner. And lastly, I wanted to update the court on the expert that has been retained. I spoke with them for the motion for changing venue. I spoke with them yesterday, Mrs. Fulford and I did, and they are intending to provide us with the end product by the end of the first week of March. And as soon as we have that, we'll be providing that to the state and get that set. Provide that to the court as well and get it set for a hearing.
All right. Concerning this report, and I'll leave this to your judgment, but do any of these matters need to be filed under seal or to alleviate essentially the issue you're complaining of for the motion?
Yes, Your Honor.
Very well. Ms. Dugan, does the state have anything to raise today?
No, sir.
Right. Upcoming through the deadlines, as we've spoken about before, the discovery deadline will be April 30th. We'll also have one last case management on March 25th at 2:30. As needed from there, we'll have different hearings on motions, and we'll continue to move to June 3rd.
Thank you, Judge.
Thank you, Your Honor.
We are in recess. Let's move on with calling the other matters this afternoon.
All right, I believe that's it for this one, but we'll just wait till Donna exits stage right. We'll wait for her officially to be kicked off.
Jill, that concludes the appearance for Mrs. Adelson. She's finished. Have a good afternoon.
She's
Thank you, you
finished.
too.
Result.
How appropriate was that? She's finished. Out. Get out. All right. So just briefly, they need to redepose Robert Adelson, who is the son, Wendi and Charlie's brother. Sergeant Corbett's deposition, they talked about that. Corbett's working on another case right now, and his presentation is more about formatting, not substantive. And then 4:30, which is April 30th, is discovery cutoff, and here we are at the 25th. So they only have, they have until Sunday. They have until Sunday to be the cutoff. All right, I'm going to go now to the one from 3 weeks ago. This was the Alfred hearing. This was to determine if Donna was going to be eligible for bail or not. So what are you guys talking about? Therapist, you know, TKO, Guy, finisher, absolutely love this judge. Yeah. Guy, she probably can't hear. Billy Moore, Wendi is selfish. She'd rather see her poor mom in prison. Yep. Hey, cases we follow. Good to see you. Thank you for joining us. Appreciate it. You have all her dates on the calendar. Cool. All right, let us get over to the next. So this is all in prepping us for today at 2:30 Eastern. We're going to pick up on Donna Live. So let's see. This one is. Let's see, this one's 3 hours. So we're going to run into that a little bit. We'll see. We'll see what happens. All right. We're going to go with this one. Okay, so this is from a few weeks ago. This is 3 weeks ago. This is the Alfred hearing to determine if Donna is eligible for bail. Let me just get rid of that pin. And here we go.
Just the rows are fine for now. Yeah.
Good to see you.
Judge, I got the email about 9:15, so,
You're not really.
okay.
Sometimes your doctor will move things along, and sometimes they will not.
Okay, thank you.
This is all been discovered. This is the trial transcript for Charlie's trial, the probable cause affidavit, the travel analysis from the court representation for the 19, from when she's on her way to just after Charlie's home, the Deadline jail, the jail call transcript, the Vietnam visa WhatsApp conversation, and this WhatsApp excerpt. Charlie and Donna. Maybe the person has a cocaine dealer and Danny was buying cocaine. And then Charlie extortion. Those two are just... Okay.
The attorneys can briefly approach before we get started. I'll give you the citation. It's 279-73262.
This is a case from the first DCA, and it basically deals with seeking to suppress what is believed to be a wiretapped interception or an interception that would fall under that statute. I'll let you do that. I didn't want this to come on associated with contrary surprise or it does establish as it relates to the subjective exploitation of privacy. I don't know what you're planning to do in that regard, but since that is the first DCA, there is no negative treatment. It is the controlling law. If you need a few moments to review it, you can do that before we start. Thank you. It doesn't change the presentation. I'm sure it would not, but it is not. It shifts more or less that it's just considered up for the rest of this block.
I have one thing to point out, not related to that, as far as the letter which we read this morning.
Suppression first and then offer.
Okay, the legal portion of that, needs, one who's the medical administrator, which is his attorney, he's going to be listening on Zoom. He says he has to be present because client testifies at a hearing, he has to go to technically. So if there's any flexibility with that at all, he's requesting we do a hearing first with the medical portion first, so
my expectation is if you've done with suppression in 35 or 40 minutes, unless you all believe this is going to take longer.
Jason,
Our first witness is Jason.
Mike,
15 minutes. But if we need to, we'll take the witness out of order. His testimony can take place if we're not done with the long hearing. Or I'm sorry, with the suppression aspect of this by 10. I believe he said the next hearing is starting at 10:30. We'll take it out of order at 10 if we're not finished with suppression by that point.
Does the court have its Zoom?
I will go ahead and open it now.
Because I think that Markel's really wants there too. Thank you.
Thank you. Good morning, Mr. Toomey.
Good morning, Judge.
We are getting everyone set in the courtroom and also getting the Zoom set as well. We are going to start at 9:15 as was scheduled today. I was speaking with the attorneys at sidebar before I turned on the Zoom, and Ms. Dugan let me know of the issue that you had with a separate hearing at 10:30. If we need to take a break as to the suppression hearing, which will start first, we'll take your client's testimony at 10, and that way it should not cause you any difficulty with moving on with your day.
I appreciate it, Judge.
All right. For everyone on the Zoom as well, the audio will remain up and running. However, there will be a still frame over my face. I'm sure as riveting as it is to see me talking, nothing else is going to be occurring over Zoom. It is all going to be taking place in the courtroom. So you understand if you hear things, but you don't see anything going on. We'll get started at 9:15, as we previously stated.
Then do 2 stickers, one for one for two, and just leave the hashtag there. And then I'll mark it as, is it one of the videos, is it 2?
Everyone can be seated. We're here this morning in State of Florida versus Donna Adelson, case number 2023 CF 3226, on the defendant's motion to suppress and also the defendant's motion for Arthur hearing or to set bond. Parties may make their appearances.
Sir, Catherine Dugan on behalf of the state. Eddie Evans is here on behalf of the state as well.
Joshua Zellman on behalf of Mrs. Adelson.
Jackie Fulford on behalf of Mrs. Adelson.
The issue that the court previously addressed with the parties at sidebar concerning Smiley versus State, and also how the burden of proof is to operate in a motion to suppress alleged wiretap statements. Is there any argument from either party concerning those?
No, Your Honor.
No, sir.
Very well. Mr. Zellman, as the defendant has the initial burden under that appellate holding, you may proceed.
Your Honor, defense's first witness is going to be Jason Newland with the State Attorney's Office. I'm told he's on his way down.
Investigator Merlin, you can come back to the witness stand. Please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
I swear.
You may take your seat. You may examine when you're ready.
Thank you, Your Honor. Good morning, sir. Can you please introduce yourself to the court?
My name is Jason Newland, Jasonnewlin.
And how are you employed, sir?
I'm an investigator with the State Attorney's Office here in Tallahassee.
So you're sworn law enforcement?
Yes, 21-something years.
Okay. And as part of your duties with the State Attorney's Office, have you been trained in reviewing calls made from the Leon County Detention Center?
Yes.
Okay. And is that through Securus?
It is now, yes.
How does that system record inmate calls?
How does it record? That's usually proprietary stuff, but I know the inmate they register an account, they set up a password, and then to complete a phone call, they have to go through a process of using their PIN, calling the number. Each party is advised the phone call will be recorded subject to monitoring, and then the called party has to accept a phone call before it's completed.
Okay. Before the call can be connected between the two parties?
Correct.
Okay. And you indicated that they're given, the inmates are given, it's a PIN number?
The inmates pick their own PIN number.
Okay. And the inmate has to enter that PIN
Correct.
Before they die?
At some point during the process, yeah.
And is that intended to ensure that the calls are tracked by the inmate making the call?
That's the intent.
Do you know whether or not an inmate's PIN can be used more than once simultaneously for calls? So if an inmate is using their PIN to make a call, that call goes through, can someone else use that PIN?
I do not know the answer.
And the Secure system, its digital system is the quality is very clear, correct?
Sometimes it's rough.
That depends on the inmate and the called party.
And the device used, you have the tablets and you also have the phone booths themselves.
Now this system, it's designed to intentionally record these calls, correct?
Yes.
And it records those calls from call acceptance to termination.
Correct.
When does the call terminate?
Usually when both parties hang up.
Now, are you familiar with the Securus call platform, SCP?
I'm familiar with how we access it. I'm not familiar with the intricacies of Securus though now.
Right, but you've been trained on accessing that in order to collect the calls.
Yes.
Now, are you familiar with a feature that Securus offers that they call covert alerts?
I'm familiar with it.
Did you create any covert alerts concerning Charlie Adelson, Donna Adelson, or any other individual that Charlie Adelson called?
I've never created one for any case.
Now, subsequent to Charlie Adelson's conviction, did you create a report that's 24 pages in length based on the calls that Mr. Adelson was making from the jail?
I did what's I would refer to as an extraction of the Securus information for a specific time period, and it produced a report.
Your Honor, may I approach the witness?
You may.
I want to approach and show you what's been marked as, for identification as defense 1. Take a look at that. Do you recognize that document?
I do. Yes.
And that's not the full 24-page report. That's an excerpt of that, correct?
Correct.
Aside from it being reduced in size to reflect what is relevant for the proceedings today, is that an accurate reflection of the report that you generated?
I believe it is, yes. If this is going to be the same one we've had prior communication about.
Yeah, this is, I emailed you 2 different excerpts, one last week and one, I believe, 2 days ago.
Yes.
Your Honor, at this point in time, I would move that into evidence as defense 1.
Is there an objection to defense 1?
No, sir.
Defense 1 is admitted at this time.
If you can give that to the judge, and I'll give you a copy.
Thank you.
Now, there is a phone call that colloquially has been referred to as the open line call, correct?
There is, yes.
And that's a call that was made July 7th, 2023 at 14:57:01. I believe it's call 562 on that report. You familiar with that call?
Yes, I am.
You have an opportunity to listen to that call.
Recently, I glazed over it a couple days ago, but not the entirety of the call. I just wanted to make sure I had the same call again.
Okay. And may I approach the witness, Your Honor?
You may.
Oh, sorry. Your Honor, let me correct myself. It's not July, but November 7th, 2023. second file on this flash drive labeled jail call enhancement for assessment. You recognize that to be the jail call at issue?
If this, I believe we sent this to Keith McElveen to see if he could enhance the open portion, yes.
And then the second call, the one I identified for you on Monday. Call number 547 at 6:38 a.m. on November 8th of 2023.
Yes,
You had a chance to review that call as well?
that one I did review.
I'd like to start with the open line call, which is call 562. Would you agree, thank you, would you agree that that call, according to this report, Exhibit 1, is 26.12 minutes length?
Yes.
I'd like to play, Your Honor, I'd move into evidence call number 562 as defense 2.
Any objection?
No, sir.
I'd like to just play the first approximately 8 minutes of that call. May I publish?
You may.
Hello, this is a prepaid collect call from an incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, press 1. Thank you for using Security. You may start the conversation now.
Yeah, sorry about that.
Investigator Newell, that recording that was just, the recorded voice that was just heard, is that the recording that you referred to earlier in your testimony?
The notification to both parties?
Yes.
That you're being recorded? Yes.
Okay.
I heard what you said, and the chief, and then it just went,
He was supposed to fly, he's the same guy who said he was going to call Dan back, for a copy, or never call him back. But Chief's back, and he's the chief of the whole jail. So come by and check me out.
so he has not been there yet.
He has not, but the psychologist, the PhD, whatever he is, she came by, and that's just getting quiet and both. So like, it's looking outside the window, just out into the hot, and it's like, you're sitting in like a what? One, it's a big text down I had before, but I just look out the window into the pot. Here, it's like a box. So you can't see it. There's a mirror, they can see in and you can't see out.
Is it any help? Can Dan get this guy to come sooner? Would that be any help?
She's back once the fucking jail. Doesn't care about what her call is. Hey, we'll come tomorrow.
And I'm sure the psychologist that you were fine, so it's just a matter of waiting for that and waiting for the chief.
Yeah, here's the record for her, and then, follow the Navy, fall. I got 33% off my phone. In the afternoon. It's okay, once it's 15%, if you switch the little battery and take her off, and then you probably get that. It's like, you just isolate, like you see it, more, of course, yeah, that's all. It's like, you do the opposite of what I would be at home. Right, in the situation.
I know, but it sounds like if it's not today, they'll do it tomorrow, but hopefully today. But then I'm in a rush, you're in a rush, they're not in a rush.
Like, I don't know all this happened, and I'll like take it out like what was around and
I know.
like the solitary
I mean, I get why it's new, but this is like, you know, the company, it's a bed on like a plastic box. And I roll up my mattress upstairs and brought it down here, and my bed sitting in my box. It's a 3 feet by 6 foot box. Put all around the center of the room where I used to walk back and forth. So, I just like walk up and then around the bed and back. It's only the same story with like they'll shut off the phones at 4, not till 6:30 back on. Is that every year? Yeah. And I'm just checking in. Okay, just checking in with me. Okay. Hey, Tom, it's there. Yeah. It's like, and it's worked hard. It's still not happening. I thought he had left. Thank you for the extra day. I get to write up. You know, so whatever it is, that they open up an inquiry to ask the judge. Okay. The investigation. You know, he said that's maybe the kind of thing. Yeah. 9 months from now, the juror writes something stupid on a blog, and they investigate, and they find out, like, and then they find out something, and they're able to open it, and then it can possibly lead to an appeal. You know, basically, the judge let a lot of stuff in to the case. And he did that because he didn't want an appeal. You know, the harder the judge rules, I guess the more issues that can come up, like that guy, Anderson or whatever. You know, I guess the harder the judge rules on issues that are in the trial, the more likely there's that of television. If the judge is in favor of the defendant, the more likely there's that of television. Yeah. You see what I'm saying? Yeah, thank you. So, my general feeling, this is just my feeling, I'm not a lawyer, but my feeling is that he ruled, if, you know, if anything, he gave the others the benefit of the doubt because he didn't want to be the government. So that would be everything. Well, I mean, he made that comment to me that the judge ruled in our favor a number of times. You know, he let us bring stuff in. And I either said it or I heard it, that he meant it, that there's not going to be, you know, what things to say that were not all. I mean, you have to either say that the judge or something didn't give your due process. You know, if you're going to do anything improper, things not right, what's your reason for wanting to trial? If there was an appeal, would it have to be in Tallahassee, when you move it? I don't understand why they would let you move it. I don't. It's blatantly, I mean, look, I didn't say this to you before I picked up the phone, but there's a lot of things that we have to do, and we've got a very tight time frame. So one of them involves taking care of some things for Roman, taking care of some things through Steinberg. It's just, Sam's been on the phone all day, and Susan was nice enough when I called her. She's going to gather everything up, and I'm going to drive down. So she and Rick got here about, I don't know, 10 minutes before you called, so that she could work with us. We've got a couple of hours of stuff to take care of for Roman. So, working on that, and you're going to be okay. You're going to get out of that stupid room. Once you do, you'll start to feel a little bit better. I know that. And when I have something that I do need to tell you, I'll speak to Dan. Okay? So, and then I'll let you know what time to call him. Can you hear me, Joey?
Investigator Newland, at that point, according to recording, Mrs. Adelson realized that Charlie Adelson's no longer on call, correct?
That's what it appears.
Okay. Now, referring back to Defense 1, that was call 562. At 15:07 or 3:07 and 7 seconds, does Charlie Adelson attempt to call his mother back in call number 561?
He does.
And then at 15:08, 3:08 and 51 seconds, does Charlie Adelson attempt to call his mom again in call number 560?
He does.
And then at 15:13 or 3:13 and 25 seconds, does Charlie Adelson attempt to call his mother a fourth time in call number 559?
He does.
And then at 15:13 or 3:13 and 51 seconds, does Charlie Adelson attempt to call his mother a fifth time in call number 558?
He does.
And then again, at 15:22 or 3:22 and 33 seconds, does Charlie Adelson attempt for a sixth time to call his mother back in call number 557?
He does.
Were calls number 557, 558, 559, 560, or 561 successful?
They were not.
And why is that?
I do not know.
Is that because his PIN was already in use?
I don't know the answer.
But does that indicate to you that Charlie Adelson had been disconnected by 15:07 and 7 seconds, or 3:07 and 7 seconds?
Yes.
Now, call number 547, the one the following morning, according to Defense 1, that call was made at 6:38 in the morning?
Yes, it is.
And you indicated earlier in your testimony that you listened to that call recently.
I skimmed through the initial 60 plus minutes to the portion where we had a similar situation as the call we just listened to.
So, Your Honor, I'd like to introduce Defense Exhibit 3 and publish. And I'm only going to publish very briefly.
Any objection from the state?
No, sir.
Defense 3 is admitted.
Thank you, Your Honor.
Hello, this is a prepaid collect call from an incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, press 1. To thank you for using.
Again, in Defense 3, did we just hear that recording saying that it was going to be a recorded call?
Yes.
Fast forward, and I'll start this at 57 minutes and 13 seconds.
What else can we have done? Anything else that we could have done that we didn't do? And now we had the best. And we had the choice of something, we had the best. And we had Tallahassee. And I don't listen. Listen. Charlie? An hour.
So at that point in time, approximately 58 minutes, a little bit past that, do we hear Donna realize that Charlie's no longer on the call?
That's what it appears, yes.
I'll call you when you haven't involved yet. I can't learn. Should I? I can't. So I'm supposed to call Dad, but that's why.
What we're listening to now, Investigator Newland, is approximately an hour, 2 minutes, and 50 seconds is when that portion of the recording started. At this point, we're at 55 seconds.
I don't have a private line. So they need to hear me tell Dad to call Annie, or they're going to hear me tell Annie? You might as well hear me. I mean, what's the option? Or are you cutting him? No? No, not necessarily. But part of the business and part of what we talked about, and it's involved.
I think I got the wrong timestamp there. Just give me a moment.
Or is it called back? I'll call you when I get off, so I'm not going to call. Maybe I'll call her before Wendi comes. I'll call her until we close and I'm going to get off, so, yeah. So the things that we wanted to him to, we'll talk about in more detail later. So our phone first, you needed to come here, but I realized that, most of everything we can do, I'll have to tell them we're leaving the country. They're not recording my phone. If they are,
They're not recording my phone. That's what you just said on the recording, correct?
Followed by something if they are something.
Now, as with the calls on November 7th, after Charlie was disconnected at about 58 minutes into that call, did he attempt to call back in call number 546 at 7:38 in the morning?
I gotta catch up with you here. So that call is the call on November 8th.
Correct. So we were talking about call 547. That's the one that was just introduced.
Okay, so at 6:38, that call was made.
So 546 did.
Yes.
And that would be on July 8th.
November 8th.
I'm sorry, November 8th, 2023 at 7:38 in the morning.
Yes.
And did that call connect?
Does not appear.
Call number 545 on November 8th, 2023 at 7:40 in the morning. Did that call connect?
Does not appear to.
And these are call number 546, 545, 544. Those are from Charlie to his mother.
Correct.
Call number 543, November 8th, 2023 at 7:44 in the morning. Did that call connect?
So 543 is at 7:45. There was 7:44, 7:45. Neither one of those connected.
Okay, so 544, 543, those did not connect.
They did not.
And those were from Charlie to his mother.
Yes.
And then call number 542 at 7:52 in the morning.
Did not connect.
Call number 541 at 7:54 in the morning.
Did not connect.
Now I want to take a step back. Adelson made was to his mother's cell phone, correct?
That is... Yes, that's what it appears to be.
Okay. And you've been on your cell phone when a call drops, correct?
Yes.
Okay. Now, there could be a number of reasons for that, right?
Yes.
It could be because of tower issues. Could be because of battery issues.
It could be numerous issues, yes.
Or it could be that the person on the other end just hangs up.
Could be.
Those are termination of those calls, correct?
For one end of it, at least.
And when that happens to you, does the call continue or is it just a stop?
A little too technical for me, to be honest.
Well, you've been on the phone, realize that somebody's not there, you look at your phone, it says call failed?
Yes.
Okay. Or there's just nothing on your screen?
Usually when the call fails, you get a beep beep and it's done.
But that's if it fails on your end, correct?
Yes.
So you've been on the phone, on your cell phone, talking with somebody. You didn't realize that they got disconnected. You're still talking, right?
Yes.
Just a moment, Your Honor. So with calls 561, 560, 559, 558, 557, as well as calls 546, 545, 544, 543, 542, and 541, those don't connect with Donna Adelson because Securus is still recording, correct?
That's too technical for me. I don't know why they don't connect.
Is Securus still recording?
It is, yes.
Nothing further, Your Honor.
Cross-examination.
Yes, sir.
So when a call is made from Leon County Jail to a person receiving that call, both parties are alerted that that call is being recorded before that the person receiving the call can accept the call and talk to the inmate. Is that right?
That's correct.
Okay. And it also lets the receiver of that call know that they need to hang up in order to not be recorded, right?
Correct.
Are there hundreds of calls between Charlie Adelson and Donna Adelson while Charlie Adelson was in custody at Leon County Jail?
I would say there's thousands.
I know that you haven't heard all of the thousands, but in most of the calls that you've heard, besides the two we've heard today, does Donna Adelson properly hang up the phone at the end of the call?
Yes, the ones that ended properly, yes.
Okay. And the defense showed you while Donna Adelson was still on the line on her and Charlie's previous call, on these open line calls, that there appear to be several attempts by Charlie Adelson to try to call her back.
Correct.
If her phone is still on the previous call and she's not looking at her phone, could it be that she doesn't see that the Leon County Jail is calling her, is attempting to call her back, like she doesn't see her call waiting because she's not looking at her phone?
That's a possibility.
And in one of the recordings the defense plays, she says she seems to be not sure that they're recording her. She says, they're not recording my phone. If they are, and then it was cut off.
No, there's more to that conversation that we didn't hear.
In that part that we heard, does she seem to be unsure whether her phone can be recorded or not? When she says, they're not recording on my phone, if they are.
Yeah, I'm not following the question here.
Okay.
I would object to calls for speculation.
I'll allow Ms. Dugan to clarify her question before an objection or answer is given.
Let me just ask then, the portion that you were played by defense counsel, in that portion, did Donna Adelson say, they're not recording my phone if they are?
Yes.
Okay. On the open line call, that the first one that the defense moved in, that where Donna Adelson talks about fleeing to a non-extraditable country, and the other information in this case from November 7th. If Donna Adelson had properly hung up, would the recording have stopped?
Yes.
And we would not be able to then hear the conversation that occurred in her home?
No.
Did law enforcement, or did law enforcement do anything to keep her from hanging up?
No.
And when I say law enforcement, I mean the state.
No.
Have you ever had a call with a friend where all of a sudden you can't hear the person and they no longer are able to hear you?
Yes.
And the call has still been pending there on your phone, it wasn't call failed?
Yes.
Would you then need to hang up the phone to ensure that the person on the other end wasn't just hearing your conversations as you went about your day?
Yes.
Okay, thank you.
Before we move into redirect, Mr. Zellman, I do have a question. I'll allow both parties to follow up. Investigator Newland, based on the records that you have in front of you, are there any instances or do you have any knowledge of there being disconnected calls prior to November 7th of 2023?
Not at this moment. I would have to go back and look.
Both parties may follow up as the court's question if you desire to do so.
No follow-up.
Briefly. And so, as you sit here today, you're not aware of any other similar situations happening in the thousands of calls?
Not in the ones that I've listened to, no.
But you could pull a report that may or may not show calls consistent with what we've presented here this morning.
Yes, I can go pull a report, yes.
And if that's what the court is asking, you could do that.
I can.
Okay. Now, when an individual such as Charlie, an inmate, makes that call, makes a call, he's using his PIN as we established earlier, correct?
Yes, he's using his PIN when he makes a call, yes.
Now I'm going to show you, are you familiar with the Next Gen Secure Communications Platform?
Next Gen Secure, I guess not.
When you download the calls and it goes into a folder on a drive or your computer, you have to click on the Show CD icon, and that pulls up a web browser, correct?
So you're talking about when I extract a set of calls, it gives us an email, it gives us a download, and the download has 3 or 4 folders in it.
Yes.
And those folders contain all kinds of stuff, so yes.
Mayor, may I approach?
You may.
This is not marked. Are you familiar with that?
I've actually never looked at this.
Now, earlier we talked about call numbers 547, 546, 544, et cetera, et cetera. I'm going to show you call number 562 on this document. take a look at defense 1, is the information consistent with what is on defense 1?
This one indicates call part, so there's a little bit more details in here.
So
And it's-
call number 561, 560, 559, did that indicate account in use?
It does.
Now, during the portion of Defense Exhibit 2 that we listened to, prior to Mrs. Adelson realizing that Charlie is no longer on the call, is there any discussion about the phrase non-extraditable country?
In the 11-7 or the 11-8 call?
11-7.
Oh, I'd have to go back and listen to it again. I know it was talking about getting out of the country and stuff like that, but I'd have to go listen to it again.
At any point in any of those calls, and this is probably more relevant for the bond, does Mrs. Adelson indicate she's not returning? Does she say she's not coming back?
No, but the 11-8 call, she did say that she's going to have to tell Wendi we are leaving the country. There was no indication of coming back from that.
Just a moment, Your Honor. Nothing further, Your Honor.
You may step down. To accommodate Mr. Toomey, we will take the one witness as to the Arthur aspect of this at this point.
Same calls Mike Hayden.
And you're going to invoke the rule for any witnesses that are here for the bond hearing?
That's fine. Please step outside and do not discuss your testimony with any other party if you are here for the bond portion of the hearings today. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? You may take your seat. Please speak loudly and clearly, Mr. Hayden. You may examine Ms. Dugan when you're ready.
Will you state your name and spell it for the record, please?
Yes, Mike Hayden, M-I-K-E-H-A-Y-D-E-N.
And where do you work?
I work for Yes Care at the Leon County Detention Facility.
Can you say that one more time?
Oh, at the Leon County Detention Facility.
Okay, and what do you do there?
I'm the Health Service Administrator.
How long have you been health service administrator there?
Since January of 24.
Can you tell me a little bit about your education, your training, and experience for your position?
So I'm a registered nurse. I started with corrections. I have 5 years of experience in healthcare administration. So starting progressively from director of nursing up to health administrator. I'm currently a travel health service administrator for the company.
Okay. What type of medical treatment can be provided at Leon County Jail?
So we are basic life-saving, so we are limited to advanced life-saving, but anywhere from wound care, chronic care medications to emergency management.
Are there people in...
Sorry, I'm having a hard time hearing.
I apologize.
Mr. Toomey, I'm just going to mute you for now. If you need to get involved in some way or make an objection of some sort, at that point, you may unmute. Please continue, Ms. Dugan.
Are there people with very serious medical conditions in Leon County Jail or who have been in Leon County Jail, even as serious as cancer?
Yes.
Okay. And what type of medical staff does Leon County Jail have up there on site?
So we have dental assistants, we have dentists, LPNs, CNAs, RNs, we have mental health professionals, psychiatrists, mid-level, so a nurse practitioner and a doctor, medical doctor.
Is there a nurse on site 24/7?
Yes.
The doctor and the ARNP, those would be the folks that can prescribe medications or refer a person to a specialist. What are their hours there?
So they're Monday through Friday.
Okay, like a normal business hours, 8 to 5? Are they on call though, other than those hours?
Yes.
Okay, what about if an inmate's having a medical emergency? They're unconscious, heart attack, stroke? uncontrolled bleeding, what happens then?
So we refer to the outside emergency room. So we're basic life saving. So CPR, we can do CPR and things like that until EMS can arrive and take to stabilize.
Okay, but anyone can say this person needs to go to the hospital,
Yes.
not even if a doctor isn't there on site?
Correct.
Okay. Do inmates have like a call button in their room where they can alert COs if they are having a medical emergency?
In some of the cells in the medical unit, yes, they do.
What about non-emergency requests? How does an inmate make a request for a non-emergency treatment?
So they have paper forms, and it's healthcare request forms, and they fill those out and they hand them to the nurse during med pass.
And the nurses are then the people who review those?
Yes.
If the nurse decides that an inmate needs to see the ARNP or a doctor, will they facilitate that?
Yes.
If the nurse decides the inmate needs to see a doctor, are the inmates then able to see the doctor, usually within a day or two?
Yes.
Okay. Even if it's on a Saturday, they might wait to see the doctor on Monday unless it's an emergency?
Correct.
Okay. I guess that's obviously depending on the nature of the request.
Yes.
Okay. In your experience, is that turnaround as far as I have this issue and I'd like to see a doctor, is that typically faster than people out of custody are able to get an appointment with their doctor?
Yes.
Does Leon County Jail provide treatment for elective procedures or things that an inmate would like to have treatment for?
So what we do is we use interqual, and that will be, it's a system of showing a medical necessity. So if there's a request, if the patient requests anything, you will see the provider, they'll assess the need, and they push it up to our utilization management team. If there is a need, then they will facilitate.
So a medical necessity?
Yes.
Okay. If Donna Adelson was seen by medical staff or is seen by medical staff for a medical necessity that they can treat, will they treat it?
Absolutely.
If it's not something that the medical staff at Leon County Jail can treat, will they get her care from a specialist for that necessity or take her to the hospital for that necessity?
Yes.
Have the medical staff evaluated her ailments listed in her motion to determine whether those are necessities or not?
Yes.
And have you had an opportunity to review her medical records before court today?
I have.
Has medical staff observed through any of her appointments any hearing loss that was noted in the medical records?
Nothing noted in the medical records, no.
Have they noted any sort of medical necessity when it comes to having her needing to see a specialist for ear wax removal several times a year?
No.
If for some reason that was deemed a necessity by the doctor in the future, would they facilitate that?
Absolutely.
But at this point, they've said they don't notice any hearing loss.
Correct.
Was after Donna Adelson complained of shortness of breath, was a chest x-ray done?
Yes.
And did it show that her lungs were clear, so to speak, nothing abnormal?
Yes, it did.
A negative x-ray. Was she given like an inhaler treatment of albuterol, though, because of her complaints of shortness of breath?
Yes, so she's had availability, they had ordered the albuterol treatment since 2023, but recently she reported that she'd had kind of an exacerbation or worsening of that. So the provider, when she listened to the lungs and knew they were cleared, she did order a scheduled breathing treatment for a few days. I think it was 5 days total.
Okay, the breathing treatment being the albuterol medication
Yes, to
that you
help
inhale?
open. Yeah.
Okay, but they did do a chest x-ray to see if maybe something
addition
more
to-
was at play here, and nothing was there?
It's clear, yes, ma'am.
Okay. Donna Adelson complained of pain in her left shoulder arm area. Was an x-ray done of that area as well to see whether there was any fractures, dislocations, something that she needed further treatment for?
Yes.
And was there any fracture or dislocation seen on the x-ray? Was that a no?
No.
Did medical staff give her some range of motion exercises she could do to possibly help with her pain in her shoulder?
Based on the notes, I think the limited range of motion was the provider's assessment of it, so there was noted that she had limited range of motion, and that's what indicated the need for the x-ray, just to see, where we were at.
Okay. So they did notice the limited range of motion, they did the x-ray, and the x-ray was negative?
Yes.
Okay. And did Donna Adelson report mild pain to the provider on February 3rd, 2025 regarding her left upper extremity with the limited range of motion?
Yes.
If either of these x-rays, be it the left upper extremity or the chest, showed need for further treatment, that showed that she does have this medical necessity that needs to be addressed, would the jail have gotten the treatment that she needed?
Yes.
Let me ask you a couple of other things. Throughout her medical records.
Judge, I'm going to object at this point.
What is the basis?
The basis of the objection is we were provided late last week, with a stack of medical records that are from the jail facility regarding Mrs. Adelson. We inquired as to what the lawful process was used in order to obtain those medical records, and we never got a response from the state. And before this hearing started this morning, I asked if they were going to introduce the medical records, and they're not. But it's clear that they've had discussions with this witness about Mrs. Adelson's medical records. They did not give notice of issuance of a subpoena so that we could object. We're not aware of any search warrant that's been given. Our client certainly didn't sign a waiver in any way. So it appears that they have unlawfully obtained the medical records of our client, and this witness's testimony should be stricken from the record and no further testimony allowed.
Still in response?
I was not aware that they did not get a response from Mr. Newland about how these were obtained. I can ask Mr. Newland what exactly his subpoena issuance entailed to get the records. I reviewed them this week since I was in trial last week, and the witness has obviously reviewed them because he's the medical administrator and would have access to them regardless. I am not moving them into evidence because I know if they're moved into evidence, then they're obviously going to be all of her medical records into evidence. I just plan to ask the witnesses about them as far as the certain things that are relevant to the motion.
So we do not have to prolong this. Mr. Hayden, if you can step down for the moment to determine how the records were obtained. As part of the motion for setting bond does go to sufficiency of medical care. In that way, if Mr. Hayden has knowledge of the care that has been given and what has taken place concerning your client, he is permitted to testify to that. As to any other records, if there's a lawful objection that you wish to make, that will be addressed. Please bring in Mr. Newman.
Thank you. Could I have a couple of questions I could ask Mr. Hayden while he's on his way down that don't pertain to the medical records?
That's fine.
Okay.
Please take the stand again, Mr. Hayden.
Just because I know we're on a time crunch with the witness on Zoom. Does the medical staff at Leon County Jail practice evidence-based medicine?
Yes.
What does that mean?
So for medicine, evidence-based is all the peer review, so past studies. It's what every medical professional should be using in the community. It's just based on prior trial and error resources, studies, research.
Does that mean that the doctors not only aren't just listening to what the inmate is telling them is wrong, but they're also looking at ordering tests, looking at x-rays, observing the patient to see if they also have any other evidence besides what the inmate is saying is wrong?
Yes.
Okay. Why might that be important to do at a jail?
Well, the majority of our patients lack the knowledge or education about their personal health. Many of them have never been diagnosed with things, especially mental health disorders. We found people have cancer and never realized it. So it's important that the providers use the community standards and evidence base to make sure we're providing the appropriate care.
Do inmates at the jail, could inmates at the jail also have a secondary reason or gain as to saying that they have some sort of medical issue that they may not really have?
Absolutely.
Is that as far as being able to get out of custody, being able to go stay in a hospital or a treatment center as opposed to being in custody at a jail?
Or attempt escape, yes.
Okay. And so is that an important reason why the jail staff turns to x-rays, their physical observations through their evaluation of the patient, or any other evidence that they can point to see that there is some medical treatment or medical necessity there?
I can't speak for the jail staff, but as far as the healthcare staff, we use evidence base to ensure that we're providing adequate care.
Okay. And does the jail prescribe narcotic pain medication?
No.
Okay. So the pain medication that Donna Adelson and other inmates receive for pain is over-the-counter type medication?
Correct.
Why does the jail not prescribe narcotic pain medication?
So that is something that usually most jails and facilities don't because it's a currency, it's highly abused, and it can cause safety issues within the facility.
So someone could say they need it and they don't really need it to support some type of addiction to it.
Correct.
Or even if they do really need it, it could cause other inmates, they could cause them to be a target by other inmates. I think that's all I have.
Are you planning to go any further examination on the line that you were inquiring of before, Ms. Dugan?
No, sir.
Step down, Mr. Hayden.
Yes, sir.
Oh, I'm sorry, before you do, please, cross-examination by the defense.
Good morning, sir.
Good morning.
Prior to coming here today, did you have an opportunity to discuss the medical condition of Mrs. Adelson with anyone at the state attorney's office?
Outside, right here.
Okay, and who did you speak with here? Female prosecutor was just questioning you? Okay. And the medical records that were provided to the state attorney's office, did you review all of those?
I did.
You did? When did you review those?
Over the course of, just knowing she's a patient of ours.
Okay. You testified, I want to make sure I understand correctly, Mrs. The prosecutor just asked you about the button being in some units where if there was a medical emergency that the inmates could alert the staff that they were having a medical emergency. Did I understand your answer to be that those are in some of the cells in the medical unit?
Yes, ma'am.
Not in the other units?
Correct.
Okay. And you indicated that the way that an inmate is supposed to request medical care is there's a form that they're supposed to complete, correct?
For non-emergent health care,
right.
Yes.
Okay, and do you know how within the staff at the jail those are given to the inmates?
Yes, they're provided by custody staff, and the nurses also carry them.
Okay. Are you aware from the records that you reviewed that Mrs. Adelson actually requested most recently on February the 1st when she was cut on the metal of a washing machine in the unit that she actually requested the nurse who was present inside the pod in the annex where she was, she requested a form so she could make a request for a Band-Aid, and they said they didn't have any? Are you aware of that?
I'm not aware of that, but I do see that she placed a sick call request and she was seen.
Ms. Fulford, before you continue, I believe you just objected to the state in any way referencing the records that you appear to be cross-examining on now.
I thought you were asking me to do my cross, Judge.
I am asking you to do your cross. However, if you are going to examine the witness concerning the records you're objecting to the state using, the state, that will be available to the state, all topics that are raised.
Then I don't want to cross until we find out how they got the records, because my cross is all about that.
Please bring in Investigator Nolan. Mr. Hayden, you may step down. Not yet. Please step down for now. Investigator, you remain under oath. Ms. Dugan, you may inquire as to how the records of the defendant were obtained as to her medical records.
How were the medical records of the defendant obtained?
By subpoena.
Let me go up to the microphone. Who did you subpoena?
Yes Care.
Is that the company who maintains the medical records for the jail?
I believe it's the medical oversight for the Leon County Detention Facility.
And do you remember the day that occurred?
So there's been twice that this occurred. We had a hearing previously, several months back, a while ago, after transport, where we had to subpoena the records, and Yes Care brought those with them then. And then last week, I got asked to draft another subpoena for records for this hearing, and that was the extent.
Was that by Ms. Kappelman or Mr.
Yes.
Toomey?
My understanding is Mr. Toomey advised Ms. Kappelman to have a subpoena drafted.
Okay, so she's asking him questions, and he says, I need a subpoena, and so then you did the subpoena?
Correct.
Okay. And then was the subpoena sent to Mr. Toomey? Or to Yes Care?
To Yes Care, yeah, which he's the representative of.
How long did it take to get the records back after the subpoena was sent?
I honestly don't know if we have them back. I haven't seen them, so I don't know.
Any other information you can give us about the subpoena process?
That's it.
Okay. Do you know if the defense, if we did receive a copy of the records, would they have been sent to defense by Ms. Kappelman's assistant?
That's standard. Once we receive it, we'll put it in discovery and provide it, yeah.
Okay. Did you have any conversations in the last week or two with the defense about the subpoena process?
No.
Okay. Anything else from the court?
I have no other questions concerning this. Does the defense have any questions as to the subpoena?
Yes, could I have just a moment, Judge? Prior to obtaining the subpoena, did you give any notice to the defense attorneys on behalf of Ms. Adelson that you were going to seek her medical records?
No.
Were you instructed to do that by anyone in the state attorney's office?
No.
Is this just typically the practice that you use, obtaining medical records without giving notice to the defense?
No, my understanding was Mr. Toomey said, please provide me a subpoena and I will bring the records with me to the hearing. That's the extent of what I understood to occur.
I don't have anything further of this witness.
Mr. Dugan, do you have any other examination as to the subpoena or the obtaining of records?
No, sir.
You may step down, investigator. Mr. Hayden, if you can take the witness stand once again. Concerning the examination of Mr. Hayden, I will rule the following. Any knowledge that he has based on his independent review of the records as a member of the jail staff providing medical care to the inmates, if he has knowledge of the defendant's records, he certainly may testify on that basis. If the defense is continuing to object to any use of the records by the state today, that will be handled as a separate matter. However, as well, if there is going to be cross-examination as to the specifically objected to records, that is going to open the door on any redirect on topics raised. You may continue your cross-examination at this point.
Thank you, Judge. You indicated in your testimony that at the jail, the health care that's provided would be for basic life-saving techniques. Is that it?
As far as emergency, yes, ma'am.
Just for emergencies?
Emergencies, yes.
Okay.
We don't have advanced life-saving medications there. They have to be sent to the emergency room.
Okay, and you also indicated in your testimony that the medical care provider, the doctor, I guess, who it is, who may be treating an inmate who's requested medical care, makes their decision based on evidence. Is that right?
Evidence-based practice.
Okay, and your evidence-based practice, your testimony could be what they observed with the particular inmate and other evidence as well. Is that right?
So evidence-based practice is, we use a standard, like community, the same level of care that you would get in the community is what we provide.
I'm sorry?
We use community-based practice, so the evidence is based on evidence-based practice.
And the evidence that you would have is whatever the inmate is providing to you, correct?
Well, so basically what it is if someone has heart failure, there's a system that we use to make sure that that patient is being cared for appropriately based on the indications, what the illness does to the body, things like that. So it's a standard way of practicing medicine.
And based on that practice, then, the standard way of practicing medicine, if someone tells you they're experiencing shortness of breath, you said an x-ray was done because she made that complaint, correct?
She was assessed, and then the provider also added the x-ray to that, yes.
Okay, and that's something that should be done as part of a normal, right? If someone says, I've got shortness of breath, you should get them for an x-ray. That's part of what should take place,
Yes,
correct?
ma'am.
Okay. As part of the medical care that's provided by your company at the Leon County Detention Facility, do you all do steroid injections in the spine?
No, that would be something that would be sent out for a consult to a specialist.
And do you do that without court order?
To provide care?
Yes,
Yes, we can provide care without a court order.
you do. That's the policy at the Leon County Detention Facility, that if a specialist is required, you will send the inmate out without a required court order if it's a non-emergency
We
situation.
send people out for non-emergency consults weekly.
Okay, great.
Almost daily. Yes,
Great.
ma'am.
And as far as the hearing issue goes, you said that the decision about not doing the procedure within her ear, that's because you all don't provide it.
Currently, we just got this request, and this is something that is new to us. We never had any history or any records of that. When she made the issue, when she put the request in, she was assessed by the provider, and the provider saw nothing on her assessment. Not to say that if there is an actual need, we can accommodate that. We can coordinate her care.
So that was a recent request as far as you understand?
Yes, ma'am.
I don't have anything further.
Redirect examination.
Recent as in the request as to the ears occurred in February
Correct.
of 2025.
So reason is, based on her medical history that she reported at the time she was looked in.
Okay. And the doctor did not notice any hearing loss at that time? Or didn't
Based
note
on
any hearing loss?
Right, based on the report, on her assessment.
Okay. And every time she's been seen, the doctors have reported that her respiratory system that appeared clear. She appeared to have no issue receiving air.
Correct.
And her oxygen levels, her pulse oxygen levels were always around about 98. Is that normal to be like between 96 and 100?
It's within normal ranges.
Okay. For the cut that she received on Saturday, February 1st, she ended up receiving Neosporin and a Band-Aid for her cut.
Yes, and then they followed up, I believe it was a week after, about 7 days after the initial assessment, the skin protocol was initiated, and they found that there was no signs and symptoms of infection, and at that time she was educated to report any signs or any worsening of the condition.
And she did receive a tetanus shot?
Yes.
Just in case. That's all.
You may step down, Mr. Hayden. Let's resume with the suppression aspect of this at this time.
Judge, may we be excused?
You're excused, Mr. Toomey. Have a good day.
Thank you.
Let's resume with the suppression portion at this time. Does the defense have any other witnesses or evidence it wishes to present as it relates to the burden in this matter?
Yes, Your Honor. Defense will call Donna Adelson.
Please come up to the witness stand, Ms. Adelson. Witness stand. Yeah. Please raise your right hand as best as you can. Do you swear or affirm the testimony you're about to give will be the truth? Yes. You may take the seat. Please speak loudly and clearly. You may examine Mr. Zellman when you're ready.
Thank you, Your Honor. Just a moment. Good morning.
Good morning.
Can you please state your name for the record and make sure you speak into the microphone?
Yes, Donna Adelson.
Now, I want to direct your attention, we heard the call earlier. The call on November 7th of 2023 at about 3 o'clock in the afternoon, and for the record, that was call number 561. Do you remember where you were?
Yes, I was in my apartment, in my living room.
Do you remember who was present when you got the call?
Yes, my husband, Harvey, and friends of mine, my attorney, Susan Brotman, and her husband, Richard Chagrin.
You said your attorney. What kind of law does Ms. Brotman practice? Or did she?
She does estate planning.
Was Ms. Brotman present at your apartment for the purposes of providing you with legal counsel?
Yes, she was.
And do you remember receiving the call from Charlie?
Yes, of course.
And where was Charlie at the time?
So he was in a room by himself. It was after the conviction.
Was he in the jail?
He was in jail.
Okay. What did you do when you saw that Charlie was calling?
Answered the phone.
And you heard the recording that we played earlier?
Yes.
And you agreed for your call with your son to be recorded, correct?
Yes.
As the call was happening, do you know at what point Charlie was no longer on the call?
No, only when because I was talking, and then all of a sudden I asked him something, and I said, "Charlie, do you hear me, Charlie?" And I said it a few times, and he didn't respond anymore, and I knew the call was over.
Now, in the course, during the time that your son was incarcerated in Leon County Jail, did that happen more than, was that a frequent occurrence?
Yeah, it happens. It happens a lot, unfortunately.
Okay. And would there be times when you didn't realize at first that he was no longer on the call?
Yes.
Where in your apartment were you when this happened?
So I was in my living room.
And you heard your voice on that first call number 562, when you repeated, "Charlie, Charlie, are you there?"
Right.
Did you believe the call had ended?
Yes.
And in times prior to this, what would happen after that? What would you do when that would happen?
If he didn't respond anymore, that was it. The call was over.
And what would you do with your phone?
I'd hang up.
Now, same thing with the call on November 8th of 2023, the one at 6:30 in the morning. Do you know at what point your son was no longer on the phone?
I don't. I don't remember the call.
In either one of those situations, or in both of those situations, did you believe the call was over?
Yeah, the call was over. He was gone.
And you went about your business?
Yes.
Now, with respect to the November 7th, 2023 phone call when your attorney, your husband, and your husband were present at your apartment, did you agree for your attorney-client conversation to be recorded?
No.
Did you agree for your conversation with your husband to be recorded?
No, of course not.
Now, the following day, did you agree for your subsequent conversation with your husband to be recorded?
No.
heard the recording. To consent to this call, press 1, or recording of this call, press 1, correct?
Correct.
And you hung up the phone after those calls were over.
Thought I did.
Just a moment, Your Honor. Nothing further at this time, Your Honor.
Cross-examination.
Good morning.
So there in the room with you during this call was, you said your, one of your attorneys, Susan Brotman, your husband, and then also Susan Brotman's husband.
Yes, that's correct.
Okay. And he was not your attorney?
He was not.
Your attorney?
No, he's not an attorney.
Okay. You were informed at the beginning of that call, this is the one on November 7th that recorded you while they were all in the room. You were informed that you were being recorded if you accepted that call?
Yes.
Okay. And that if you do not want to be on that recorded call, that you needed to hang up the call. Is that right?
Are you saying, does the recording say?
Right. If you do not want to accept that recorded call, you should hang up.
If you do not, yeah, no, I accepted the recorded call.
Okay. And you typically do hang up your calls, you said, after
I mean, I think I did,
your calls with
yeah.
Charlie Adelson when he was in custody. All right, but this particular call that day, evidently you did not properly hang up, right?
Evidently.
Okay. And have you ever forgotten to press the button on a call before?
I mean, it may have happened. I don't know.
Sure. Has your phone pocket dialed people before?
Has it what?
Pocket dialed people before? When you've been out of custody.
Pocket dialed?
Right.
I don't know what you mean.
Like if your phone is in your pocket or in your purse and it accidentally calls someone you didn't mean it to?
I mean, that could have happened, sure.
Okay. And you also could have not pressed the button on your cell phone to end a call before, right?
It's possible.
Okay. It's not quite as big of a deal as it used to be when you would actually have to like hang up the phone. Right. Okay. That's all. Thank you.
Redirect examination.
Briefly, Your Honor. The consent that you gave for the call to be recorded, when did that end?
It ended when Charlie hung up, or when whatever stopped the call. I mean, I don't know how it stopped, but it stopped. When the call was over with Charlie, it was over.
Nothing further.
You may step down. As to the burden at this point, under the precedent established by Smiley versus State, in order to exclude what are complained of wiretapped interceptions, the movement has a need to show there was a subjective expectation of privacy in their statements, and the expectation is one that society would accept as reasonable. As to the subjective expectation showing the defendant has met that burden, it now shifts to the state as to whether this is one that is reasonable. Ms. Dugan?
Yes, sir. I have argument.
You may proceed.
May I provide the court with some case law?
You may.
I've got some argument and then I'll kind of go through each one of these cases. I provided defense a copy of these earlier this morning. So in defendant's motion, they first argued that this was, a warrantless search. However, the state's argument is that this is not subject to Fourth Amendment because there's no wrongful state action that caused this defendant to be recorded after the inmate was no longer on the call. The only conceivable state action here was the state having this service that allows inmates to make recorded calls. But on those calls, both parties have to consent to be recorded for the call to begin. And if they do not want to be recorded or need to hang up. The state didn't intend to record this defendant's conversation in her home with her husband and friends. And it was the fact that she was recorded was not caused by the state's actions. It was caused by the defendant's actions. The defendant argues that they have this reasonable expectation of privacy in the call, but that would only start once this defendant actually hangs up. And the defendant is the one responsible for hanging up, not the state. The defendant was responsible for the interception of the phone call. It was her failure to hang up that caused that rest of that call to be recorded. It was her action and not the state action that made that happen. The state did nothing to keep her from hanging up the phone or prevent her from hanging up the phone. I think an analogy here would be if someone were to say something incriminating in earshot of a law enforcement officer because they think the law enforcement officer can't hear them. If they can actually hear them, then that's on the speaker because the speaker didn't walk away to talk. That was the speaker's carelessness. The defense also cites Florida Statute 934 and says that the good faith exception doesn't apply because this call was in violation of that statute. But when you look at 934.03, every single subsection of that statute applies to intentional intercepts, not accidental. I provided several cases to the court. There's nothing directly on point here of this situation having happened just like this in the past, but there are a lot of cases that deal with inadvertent recordings. One of the first cases I gave to you is Baronet. This is a U.S. Court of Appeals case from the 6th Circuit that held that police interception of conversations between the defendants that was overheard when a telephone that was subject to a court-authorized wiretap was inadvertently left off the hook by the defendant. That was authorized under the plain view exception to the warrant requirement. In that case, the state had an actual Title III wire on the defendant's phone. The defendant was on a call and then didn't properly hang up the call. They left the phone off the hook accidentally. And then law enforcement was able to hear the conversation in the room where that phone was located. So when you compare that to our case, there's obviously, a much different type of state action in that case with a wire. But regardless, this was a recorded line. It was a legally recorded line where they consented to be recorded. Just like in our case, though, the defendant in that case failed to properly hang up, and that allowed law enforcement to hear the conversation in the room. And that was able to be authorized because of the inadvertent nature of the recording. Another was Otero versus State. This is a 3rd DCA case from Florida where a child accidentally activated an answering machine of a home that she was staying at. And that answering machine recorded the conversation of the mother and the child unbeknownst to either of them. The 3rd DCA found that admission of that tape into evidence did not violate the statutory exclusionary rule found in 934 because 934 prohibits intentional interception of wire communication. And that taping in that case was accidental, not intentional, just like in our case. There's another case that I provided to the court, Bell versus State. In that case, a girlfriend began to record her conversation with her boyfriend, who was the appellant. And that conversation that she wanted to record was about money, an argument about money between them. The appellant, Bell, then took the phone from her and kept the phone after the argument ended and the girlfriend left the house. The girlfriend's young daughter was still at the house, and after the girlfriend left, the defendant was intoxicated and forgot to turn off the audio recording. There was then a recording that, as the recording kept going, it recorded him molesting the girlfriend's young daughter after the girlfriend left the house. The girlfriend then discovered the audio recording next day and handed it over to the police. The defendant was charged with L&L molestation. In that case, the recording of this molestation was obviously inadvertent, and the defendant agreed with that. Only the first conversation about money was what the girlfriend was trying to intend before the phone was taken from her. And that phone was in the appellant's custody and control at the time of this recording of the L&L molestation. The DCA in that case said that the trial court did not err in concluding that Mr. Bell failed to prove that his girlfriend intentionally intercepted the portion of the recording that took place while she was gone. Unless his girlfriend intentionally violated the statute, he was not entitled to the benefit of the statutory exclusionary rule. Because the recording was not surreptitious, but after she warned him she was going to record him, he took possession of the device that recorded his words and actions. And so the court found that the appellant did not establish that the communications were intercepted under any circumstances justifying an expectation of privacy. I have one more case that concerns the reasonable expectation of privacy. This is the Huff case that I provided to the court, which is a federal case where the plaintiff, a federal civil case, where the plaintiff inadvertently pocket dialed the defendant, which is something that, has happened to us all. And the defendant listened to and recorded the conversation she overheard while on the pocket dial call. The plaintiff then brought suit for the defendant intentionally intercepting this private conversation. And in that conversation, the plaintiff was basically having a discussion with his wife and with other people as well in the room. The court ruled that the plaintiff's statements did not qualify under Title III because he exposed them to the defendant when he pocket dialed her. But the plaintiff's wife's statements did qualify. She can't be held responsible for her husband's pocket dial. But the thing that I think is most important about that case is the court's holding that a person who knowingly operates a device that is capable of inadvertently exposing his conversation to third-party listeners and fails to take simple precautions to prevent such exposure does not have a reasonable expectation of privacy with respect to statements that are exposed to an outsider by the inadvertent operation of that device. So in that case, the statements didn't qualify under as ones that were protected under the U.S. Code. And that's what we have here. We have the defendant failing to take simple precautions of properly hanging up what she knows is a recorded call. So the state would ask that the defense motion be denied.
Final argument on the motion to suppress from the defense.
Yes, Your Honor. There are two cases. I cited a number of cases, and I know Your Honor's practices review those in addition. There are two additional cases I provided copies to the state that I am relying on. The first is Hentz versus State, 62 Southern 3rd, 1184, and State versus Mozo, 655 Southern 2nd, 1115. May I approach?
You may.
Thank you. So, Your Honor, I want to start with a very general proposition that's important for us to remember. Right to privacy is enshrined in the Florida Constitution. Article 1, Section 23 provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures and against the unreasonable interception of private communications by any means shall not be violated. Article 1, Section 23, the Florida Constitution also provides that every natural person has a right to be let alone and free of governmental intrusion into the person's private life. Fourth Amendment includes similar protections. 934.02 defines an oral communication as any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation. The courts have held in Florida, as cited in my motion, for an oral conversation to be protected, the speaker must have an actual subjective expectation of privacy along with a societal recognition that the expectation is reasonable. Your Honor, State versus Mozo, almost 20 years ago, courts have held that conversations, oral communications taking place in one's home are protected by Chapter 934.
I don't think this point is reasonably in dispute, but go ahead.
Now, the question, obviously, is the objective portion of this test. And Hence versus State, 4th DCA, and Hence is a situation, Your Honor, where an individual was in an interview room at the police department. He placed a call to essentially a co-conspirator, co-defendant, and the recording equipment was powerful enough in that interview room to pick up the other end of the call that is made to Hence. Based on what law enforcement heard from the individual's call, the individual who is calling Mr. Hence, they obtained a search warrant for his cell phone. And on that cell phone, they found images that are illegal to possess, as well as other evidence of a crime that the two of them engaged in. The Hence court held that, and another important factor, Your Honor, Mr. Hence was aware that the individual on the other end of the phone was at the police department waiting to speak to law enforcement. Court held that Hence had a subjective expectation of privacy, and his expectation was one society accepts as reasonable. Now, one distinguishing factor I need to acknowledge is that, but I submit it's not dispositive, is that while Hence did not know that the individual was sitting in a police interview room, whereas Mrs. Adelson knew that Charlie was in jail and had consented to her call with Charlie being recorded. But the oral communication that is protected by Chapter 934 that is at issue here are the conversations that Mrs. Adelson had after Charlie dropped off the call, when she believed the call was no longer being recorded. Conversation, at least with respect to the November 7th, is with her attorney and her husband. Both are confidential relationships.
Doesn't the warning, though, about the recording almost directly speak to that issue where, I'll read the case that you've given me about Hence. Although he knew his friend was at the police station, he never received an explicit warning about you may be recorded if you continue on this conversation.
Correct, and I'm going to get to that, Your Honor.
Go ahead.
Thank you. The testimony, uncontroverted testimony, is that Mrs. Adelson believes she hung the phone up once she realized Charlie was no longer on the call. There's no evidence otherwise. And I don't think it is reasonable to require an individual in a situation like that, I just had a recorded phone call, let me repeatedly hit the end button. You hit it once, that should be enough. She believed that she ended the phone call. Now, Hence also addressed something else that I think is important. Chapter 934.03 is a general intent statute. It does not require that the state intentionally recorded after one party of this jail call drops off. It's not required. Was the system designed to intentionally record? The answer has to be yes. Investigator Newland testified, yes, intentionally designed to record. Now, the state, I anticipated that they would argue accident or inadvertence. This is not an accident. An accident is something that doesn't happen frequently. Mrs. Adelson testified that this happened. The call, Charlie dropping off the call, would happen frequently. As Investigator Newland acknowledged, Defense Exhibit 3 and Defense Exhibit 1 established this was not an isolated issue. This happened. The system is intentionally designed to continue recording. Under Chapter 934, I submit that when either side of the call is no longer on the call, that the system has to stop recording, and any additional recording is a violation. And that's what we have here. This is not an accident. This is not inadvertent. Securus Technologies system is designed to continue to record after either one of those parties drops off the call. Investigator Newland said that it terminates when both parties hang up. Well, I submit, Your Honor, that that's not what happens. It continues to record, and it is not reasonable. And society is not expecting that somebody sit there with their phone and continue to hit the end button to make sure that the call stops on their end. I think that's unreasonable.
But do you have to continue to hit the end button, or you hit it once and it's disconnected?
Testimony is that she believes she did.
Go ahead.
So, because this is not a specific intent statute, is the system designed to intend to record? Yes. And there's no evidence that this was accidental or inadvertent. This is not a pocket dial, as the state argued. We know that Charlie intentionally called his mom. We know that the system intentionally recorded the call. The state has not presented sufficient evidence to establish that this is not a communication that society's that there's a reasonable expectation that society would accept that this call is anything other than something that is entitled to the protection of 934 and the Florida Constitution.
And we'll review the cases that were presented by both parties before making any ruling. I'll reserve on the ruling as to today. We'll take a brief 5-minute break before we get into the Arthur and Baum motion. We'll be in recess.
Thank you.
All right, we're going to zoom while we can.
On to the second part of the hearing this morning, the motion to set bond and also for Arthur hearing.
Thank you, Judge. May I put one more thing on the record for the suppression that I had in my notes and I forgot to say it?
Only one?
One.
Just one?
Just one.
Go ahead.
So in the call that the defense moved into evidence, the call from November 7th, that's in dispute here. At the end of the call, Harvey Adelson says something along the lines of, it's the last thing that you hear, something along the lines of, what's this? A call that didn't end. The implication being he must have picked up the phone and saw that the call didn't end. I think this is important to note because had Donna Adelson looked at her phone, she would have seen the same thing. That's all.
Well,
may I have a equally brief response?
59 seconds exactly.
Thank you, Your Honor.
Go ahead.
Your Honor, the system, the Secure SAS is intentionally designed to continue recording after the inmate disconnects. And the system knew that Charlie had been disconnected because he tried calling back, and the system reflected, as Investigator Newland testified, account in use.
Let's move on to the Arthur hearing at this portion. Is the defense wishing to present its argument as to bond, or is the state going to present first as to proof of guilt evident or presumption grade?
I'd prefer we do bond first, if that's okay with the defense, just because the state does have a couple of witnesses as to the things they brought up in their motion. And then I'm not calling any witnesses for Arthur. I'll just be moving some things into evidence, so maybe we could do that last.
Mr. Zellman, as to the bond portion of this, do you have witnesses?
We do, Your Honor. State would call Donna Adelson.
Ms. Adelson, you can retake the stand once again. You remain under oath. You are sworn to tell the truth. You may examine when you're ready, Ms. Fulford.
Thank you, Judge. Ms. Adelson, at the commencement of the hearing on the motion to suppress, you said your name for the record, Donna Adelson. Can you tell the court how many times prior to your arrest for the charges that are pending in this case have you been arrested for criminal offenses?
Never.
And how long have you been incarcerated at the Leon County Detention Facility? Do you recall?
15 and a half months, 470 days.
And within that period of time, the 470 days, have you been held in the same location in the Leon County Detention Facility or different locations?
Different locations.
Okay, and your first location was where?
First location was in solitary confinement on a direct observation unit.
Do you know how long you were there?
50 days.
Okay, and where did you go following solitary?
To the N pod, like N is in November. It's an open pod, general population.
And what does that mean, open pod, general population?
So I was with 60 some odd other inmates, all in one open area.
And you had beds in your room, I assume?
There were each sections off about 10 women. So, and there'd be a cement wall, and then there'd be another 10 women and a cement wall. So it was fairly quiet, actually, even with that many women, because we were separated in small groups, so it wasn't that loud.
Okay, and do you recall when you were taken out of the N like Nancy pod?
Yes, in August, they said they had maintenance to do, and that we would be moved to the annex, which is a building outside of the jail.
Okay, and so I'm not going to be specific as to dates, but you were arrested in November of 2023 in solitary confinement for 50 days to whatever date that took you to.
January 9th.
Okay, and then from January 9th all the way through some date in August of 2024.
Correct.
You were in the N like Nancy pod. And then you said you were transferred to the annex. Can you describe the conditions inside the annex, please?
So the annex is kind of a temporary type building. It's not a brick building. It's kind of like a temporary building, and it's and there are 66 women, all in bunk beds, all open. You're kind of one on top of the next. There's no separation at all.
So one big open room,
One big open room with 66 beds, yes.
Okay, and how long did you stay? So from August of 2024 until when? How long did you stay in the annex?
I was moved again on February 3rd, 2025.
Okay. Okay, and you were here when the gentleman was testifying about the call buttons to alert someone if you're having a medical emergency. Was there one of those in the N pod?
No.
Was there one in the annex?
No.
Okay. I'd like to start the motion for a bond that we filed in this case. As the court indicated earlier, one of the issues that we have raised are medical conditions that you're facing. So I'd like to start with your medical conditions and present some testimony to the court about those, okay?
Okay.
Okay. We're not going to go over every medical condition you've had since you've been incarcerated in the jail, but I'd like to start with one that you have that's causing you some pain in your leg and back area.
Yes.
Okay. Let me just start with this. Can you describe to the court the kind of pain and discomfort that you're having with this particular injury or issue?
Yeah, it's I know what it is because I've had it in the past. It's sciatic pain, and I get like a pulling kind of shooting pain down my legs.
Okay. And you said you've had it in the past. Do you mean prior to becoming incarcerated at the Leon County Jail?
Yes.
Okay. And during the course of time before you were incarcerated at the Leon County Jail, did you seek treatment for that condition?
Yes, I did.
And what type of treatment did you obtain for that?
So I saw my orthopedist, and he gave me a steroid injection in my spine.
Okay. How long were you suffering from the sciatic condition prior to becoming incarcerated?
How long the last episode was?
Before you were incarcerated in jail, for how many years had you been suffering with the sciatic issue?
So no, I had it last about 10 years ago. I haven't had it all this time.
Okay.
But then it recurred a few months ago.
Okay, and what was the treatment that you were provided prior to your incarceration for your sciatic condition?
It was the steroid injection, and within 48 hours, it was gone. The pain was gone. It was amazing.
And where did they do the steroid injection? Where is that in your body?
In my spine.
In your spine, okay. Is that an outpatient procedure, inpatient?
Yes, outpatient.
Outpatient, okay. All right, and during the course of time that you've been in the Leon County Jail, did you start to experience the sciatic pain again?
Yes, it did.
And what did you do when you started to experience that pain?
I wrote a sick call, and I went to see the doctor.
Okay. Where do you get these sick call forms from?
From the nurse.
Okay. And when do you have the opportunity to see a nurse to get the sick call forms?
Well, they come twice a day. They come in the morning and they come in the evening.
Okay. And we'll get to what those times are at a later point. But if you don't get a form from a nurse, is there another way to obtain it that you're aware of?
No, that's the only way I've ever gotten it is from a nurse.
Okay. Do you recall approximately how far into your incarceration you started having the sciatic issues again?
I didn't have it until I was in the annex, so that was sometime over the last, I've been there 6 months. I don't remember the specific date, but I didn't have it before the annex.
Okay, and once you started experiencing it in the annex, did you complete a form to see medical attention?
Yes, I did.
Okay, and as a result of completing that form, did you have an opportunity to meet with someone in the medical center at the Leon County Jail?
I saw the doctor there, yes.
And what happened?
And I explained what I had, and she said, we do not treat that type of problem. We could offer you some Tylenol.
And did they provide you with Tylenol?
They did.
And has that relieved you of the pain that you suffer?
No, it's Tylenol. It's not going to do what I need to have done. No.
Okay. So sometime since you've been in the annex, you made your first request for treatment for the sciatic issue. Have you requested treatment more than once?
Yes.
Okay. And have you received any additional opportunities to meet with any of the medical staff regarding this pain?
No.
Okay. What happens when you request treatment and you don't get to see them? Do they tell you that you're not going to be allowed to see them again? What happens?
No. Usually I wait a week, and if I don't hear anything, then I'll write another one, and I'll write, this is a second request, or this is a third request. And then I think they said I think I got an answer. They sometimes just answer it and give it to the pod officer, and she'll hand out papers at night, which is the response to your requests. And on that one, they said you're already getting pain medication for this. That was the Tylenol.
And the pain medication is just regular Tylenol?
Regular Tylenol.
Okay. At some point, did you have an opportunity to speak to someone in medical care regarding potential way to resolve some of the pressure in your leg for use of a medical mattress?
Yes. While I was down with the doctor during one visit, she said, you know what might be helpful, because you're sleeping on metal and the mattress is maybe a ½ inch thick, maybe. She said what would help is if I could get a medical mattress for you. I had never heard that term before, but I said, okay, if you think it'll help, that would be great. And she left the room, she went into another room, and then she came back in and said, yeah, I thought that would be a good idea, but they don't have it here. So my best thoughts for you would be to get a second mattress, so it'll thicken it a little bit, and that might give you some relief at night.
Okay. And did you obtain a second mattress?
I did.
And this was while you were in the annex?
While I was in the annex.
How did you get the additional mattress?
So the pod officer asked one of the inmates to go where they have extra mattresses. They have piles of 20, 30 mattresses there, to go get one of the extra mattresses and put it on my bed so that I had the extra mattress.
Okay. And during the time that you were allowed to have the additional mattress, did you get any relief?
Yes, at night, because I used to get the pains even if I was just lying down. And that definitely relieved some of the pain at night, so that was good.
Okay. And at some point, did they take the additional mattress away?
Yes, so on February 3rd, I was moved out of the annex to protective custody in the main jail building. And since I've been there, the officer removed the second mattress.
Okay.
She said, "Why do you have this?" And I told her why. And she said, "Well, you can't have this."
And
so they took it away.
Okay, and since the additional mattress has been taken away, have you started to experience worsened pain?
Yeah, it's worse.
Okay. And have you requested any medical treatment for that?
Well, I spoke to the doctor, I don't remember the date, shortly after it was taken away. I was down for a different reason, and she said, yeah, I thought it was a good idea, but if you can't have it, you can't have it.
Okay. All right. Now, the relief that you got when you were able to have the additional mattress, did that completely take away the pain?
No.
Okay.
No.
And do you experience this pain when you're walking, sitting? What?
So at the beginning, I was just getting it when I was walking. So it limited the amount of walking I could do, but I get it when I'm sitting, I get it lying down, I get it all the time now. So it's not like I have it all the time. It comes and goes, but when it just comes, I could be sitting, I could be standing, it just happens.
Okay. We're going to go into more details about how it took place in a few more minutes, but for now I'd like to talk about, are there any other areas that you are experiencing any pain?
Yes, I have a problem with my left arm.
And describe to the court what that problem is, what you're feeling, what you're experiencing.
Okay, so I have like shooting pain from the top here of my shoulder down the outside of my arm into my forearm.
Okay, and you're pointing to your left arm. Is that the one you're referring to?
It's my left arm.
Okay, and so shooting pain down the arm. Anything into your hands?
Yeah, the pain is like hot. It's like a burning pain, and my thumb, index, and middle finger have gotten like tingling. It almost feels like ants are crawling on them. It's like a numbness of those fingers.
Okay, and is this pain that you were experiencing prior to your incarceration at Leon County Jail?
No.
Okay, about when did this pain begin?
So I was assaulted by another inmate while I was here the beginning of October.
October 2024?
Yes.
And when you say here, do you mean the Leon County Jail?
Yes.
Okay. All right. Since you began experiencing that pain, since October of 2024, have you requested medical treatment?
Yes.
And what has the response been?
They said they would take an x-ray, but in the meantime I could have Tylenol.
Okay. And you said that was in approximately October of 2024. Have you been requesting treatment for that pain since October of 2024?
Several times.
Okay.
Yes.
And you heard the testimony of the gentleman previously. At some point, did they do an x-ray on your arm?
Yes.
And when was that?
It might have been February 3rd. No, that was the day I moved. It's shortly after February 3rd. I don't know the date.
Was it after you were removed and placed in protective custody?
Yes, it was.
Okay. Is the Tylenol helped with the pain that you're experiencing?
No.
After they performed the x-ray, were you called back into the medical unit?
It was for another reason, but they did call me and they told me that the x-ray showed no fracture.
Okay, no fracture. That's what they were looking for?
That's what they were looking for.
Okay. Did they offer any type of physical therapy for your shoulder, anything at all?
No, I asked if they could do anything for it and they said no.
Okay.
Tylenol.
All right. Do you have any other medical conditions that you wanted us to address in the bond hearing that you're suffering from?
So I have a hearing issue.
Okay.
I have a problem. I evidently have very narrow ear canals, and so doing the wax builds up in my ears to the point that, I mean, I have officers that say to me, "Are you deaf, Adelson?" When I don't respond to them, it's because I don't hear them. And so I did ask for help in the, I asked the doctor if there was anything they could do for me, and I told her what's normally done, and she said, we use Debrox to soften the wax, and then you come down 3 or 4 days later, and we use a bulb syringe to remove it. And I said, that doesn't work. I need a different procedure. And she said, that's all we can do for you.
Okay. And did you know, based on your prior treatment before you came into the Leon County Jail, that it required something other than the flushing system?
Yes, I did know.
Do you recall the name of the doctor that you saw for this condition?
Yes, I've seen him for years. Dr. Molina.
Okay. And Dr. Molina, how long do you think that you saw him for this condition prior to your incarceration?
I mean, several years.
Okay.
4 years, 5 years, I don't know.
Okay, and during the course of his treatment for you, how often would you go to have the wax removed from your small ear canals?
Yeah, every 3 to 4 months. If I waited longer than that, I couldn't hear.
Okay, and did he use a flushing method, or did he do something different?
No.
What did he do?
He used some kind of, I don't know what it's called, but it's some kind of an electronic device that he puts one end in my ear, and he's able to remove the wax using that device, that medical device.
And in your experience prior to incarceration, when you were having that procedure done, did your hearing improve?
Immediately.
Okay.
Yeah, immediately.
May I approach the witness, Your Honor?
You may.
Mrs. Adelson, I've shown you what the defense has marked as Defense Exhibit 1 for purposes of this hearing, and it's a report from Dr. Molina, your doctor. Could you review that just to yourself for a moment? Okay. Does that describe the treatment that he was providing to you?
Yes.
Okay, and it includes a recommendation that you continue to receive the same treatment, potentially with another ENT in Tallahassee, is that correct?
Yes.
Okay. This time the defense would offer Defense Exhibit 1 into evidence.
Any objections to Defense 1?
No, sir.
Defense 1 is admitted.
Yeah, First Your Honor.
You may. Thank you.
During the time that you have, without disclosing any of the conversations, of course, but during the course of the time that you have met with counsel at the jail, have you had difficulty hearing us while we're trying to discuss your case with us?
Yes.
And what about over the telephone? Are you experiencing difficulty hearing us in that way?
Yeah, the telephone is a problem.
Okay. Have you actually gotten in trouble by some of the guards at the jail because they've instructed you to do something and you weren't able to hear them?
Yes.
Has that happened on more than one occasion?
It's happened on several occasions.
Okay. And have you experienced over the course of your incarceration that your hearing is getting worse and worse?
Oh, yeah.
Okay. All right. This is not a significant, I'm going to move on to something else now, and this is not a significant injury, but I did want to address this with respect to the type of medical care that you are getting at the jail. Did something happen to you recently where you cut your arm?
Yes.
Okay. Tell the court what happened, please.
So I was walking past the washing machine on my way to the restroom, and I bumped into there's like a metal bracket that holds the washing machine in place, I guess, and it was my fault. I bumped into it.
And what happened?
So I cut my arm pretty badly.
So what did you do after you cut your arm?
So the timing was it's kind of interesting because the med nurse was there doing morning meds. So I got onto the bleeding wouldn't stop. It was just pouring out. And so I figured I'll get on the line with the other girls and I'll speak to the med nurse. So I waited my turn and I got to the med nurse and she says, "Whoa, what happened to you?" And I said, "My fault. I just bumped into the washing machine and I cut myself." So she looked at it and she said, "Yeah, that's a problem." I said, yeah, can I get a Band-Aid or gauze or something, some antibiotic cream? She said, yeah, I don't have any antibiotic cream and I don't have a Band-Aid. So I looked at her and I said, well, what should I do? She said, well, why don't you use your toilet paper and put it on there? I said, but it's gushing. I can't put toilet paper on there. So one of the girls saw me and she said, oh my God. And she came running over and she opens up a sanitary napkin and she put it on there so that it was filling the sanitary napkin with blood. And so another girl came over, she took the bloodied one away and she gave me hers too. And I was applying that. So I said to the nurse again, I'm not going to be able to stop it holding this. Isn't there something you can do? She says, the best I could offer you would be to fill out a medical request form. So I said, you want me to do that now? She said, yes. I said, okay, can I have a medical request form? She says, oh, I don't have any. I said, well, what am I supposed to do? And she said, I don't know what to tell you. She said, maybe the night nurse will have that.
Okay, so this was just a couple of days before you were transferred to protective custody, correct?
Correct.
Okay, but do you recall that it was on Saturday, the 1st of February?
It was a Saturday morning, yes.
Okay, and so about what time of morning would this have been if this was the morning med nurse?
It could have been 9 or 10,
Okay.
somewhere in the morning.
Okay, and when she told you that she didn't have any sick call forms for you to request a Band-Aid and you would need to get it from the night nurse, approximately what time does the night nurse come?
So the night nurse comes anywhere from 11:30 to 2:30 in the morning.
11:30 p.m. to
PM.
To what time?
2:30 a.m.
To 2:30 a.m.
Right.
And in the meantime, you were supposed to use the feminine pads?
I called my husband. He told me to elevate my arm, to wash it, to try to wash it frequently, just to keep my arm up, and that's what I did. And one girl brought over toilet paper, but that was sticking to the wound, so that wasn't good. So I kept borrowing sanitary pads to hold it.
Okay, and at some point, did the night nurse come?
Yes, she came that night.
Okay, and what happened when she got there?
She didn't have a Band-Aid either.
Okay.
She didn't have antibiotic ointment either. And I said, this has been going on since early this morning.
Judge, I'm sorry to interrupt, but I just turned around and noticed that some of the state's witnesses have re-entered the courtroom. We had previously invoked the rule for the bond proceeding.
All right. And for anyone who is here to testify concerning bond, please step outside the courtroom. Ms. Dugan, is any witness you're intending to call currently in the courtroom?
I don't see any. I'm calling Miss Wilson and Deputy Collins.
Please continue with your examination, Ms. Fulford.
Thank you. So the night nurse came and the night nurse didn't have a Band-Aid either?
No antibiotic, no Band-Aid, and no the form that I was told to ask her for, the sick call form. She said, I don't have them. We haven't had them in a while.
The night nurse?
The night nurse.
So how were you supposed to request, according to the night nurse then, how were you supposed to request assistance?
So I was actually fortunate because there was a sergeant with the night nurse. She accompanies the nurse when she comes there. And she took a look at what I looked like, and the night nurse said, yeah, that's a problem. And so the sergeant said, I'm going to make sure you get a Band-Aid, and I'm going to make sure you get a form. You'll get it by tomorrow. When I go back with the night nurse, she said, I'll run some off on the machine, some copies, and I'm going to make sure that you get it.
And did she?
The next morning.
Okay.
The next morning I got it.
From the sergeant?
From the sergeant, yes.
Okay. You got the Band-Aid and the call nurse?
Yes.
Call form?
The call form.
Okay. May I approach the witness, Your Honor?
You may.
Yeah. Adelson, I'm showing you what the defense has marked as Defense Exhibit 2. Do you recognize what's in that photograph?
Yeah.
And what is that?
That's a few days after after I got cut, and that's the clear Band-Aid that they gave me to put on top.
Okay. After you got the bandage to put on over your wound, did you get additional medical treatment for the wound?
So no, not then, about, I don't know how many days later, but when I went down to medical a few days later, they said, how long are you wearing this bandage? And I said, I don't know, 4 or 5 days, whatever it had been. And they said, this should have been cleaned and changed every day. Why didn't you have that done? I said, I don't know. This is what they gave me to put on, and that's what I did.
Okay. The photograph, does that truly and accurately depict what your injury looked like the few days after it occurred with the bandage on it?
That's what it looked like.
The defense would offer Exhibit 2 into evidence.
Any objection to defense 2?
No, sir.
May I approach?
You may.
And at this follow-up visit, then, did they change your bandage and clean the wound?
They cleaned it, and they put antibiotic cream on it, and they changed it, yes.
And did you get any additional treatment for the wound?
No.
Did you request that you get a tetanus shot?
My husband said, Donna, if there was rust on that metal, which there was, he said, you should ask for a tetanus shot.
And so did you request
So
it?
I requested it, and they did give it to me.
Okay. And then, as far as your medical conditions go, the last thing I want to talk about is something that I would give 2 different descriptions of, but I'm just asking the questions. You're the one providing the information to the court in your testimony.
Okay.
So this shortness of breath or heavy breathing that you're experiencing, how long has that been going on?
It's been going on several months, probably at least 3 months, I would think.
Okay. And did you're experiencing it then during your incarceration? Did you have it prior to being incarcerated?
No, I did not.
Okay. What have you noticed about the breathing, and how would you describe it? Shortness of breath, heavy breathing, what?
I know it. I guess it sounds like heavy breathing. It's shortness of breath. I've never had that before. I'm not a doctor. I don't know. I've gained more than 1/3 of my body weight here. The diet is all carbs, no protein, and when you get spaghetti with mashed potatoes, cornbread, and white bread, that's your dinner. It's very typical of what we get. And we have had no exercise at all. We're confined, especially in the annex. The annex, we've been confined to our beds almost all the time. Once in a while, we get a pod officer that lets us walk, so you can walk in a circle around the girls' beds. But otherwise, there's no, even if you want to get off your bed and just try to do stretches or wall push-ups or anything, she says, this is not an exercise room, there's no exercising here. We don't get taken outside.
Let me stop you. One of these issues at a time. So with respect to the time period when you've been in the annex, which was from August of 24 until recently February of 2025, was it your understanding you're supposed to be taken outside a certain number of times?
Well, the inmate handbook says you get a minimum of 3 hours of outside time per day. Per week, per week.
Okay, and during your time in the annex, did you experience a week where you got 3 hours of time outside?
We haven't gotten 3 hours in 6 months.
Okay. How many times did you go outside while you were in the annex?
Before you continue, Mrs. Adelson.
Yes.
We have 30 minutes left in the hearing. Ms. Fulford, I understand your client is disputing the adequacy of the care. We do need to move to the most pertinent matters. Please continue.
Okay. We're going to move off of that then. I do want to talk to you then about some physical issues that have taken place in the jail. The first one I want to talk about is an incident that took place in the shower, and we're going to do this one briefly. I'm sorry, how much time did you say we had, Judge?
30 more minutes.
Including argument?
Not including argument.
Okay. All right. So the first incident that took place in the shower, could you just briefly describe to the judge what happened there?
Yeah, so I always, there's 7 shower heads, but I always take the same one because It's off in a corner, so I have a little bit more privacy than you'd have at the other ones, and so I would always shower there, and I was under the shower, and I was washing my hair, and I was the only one in the shower. I always go in early morning because there's nobody there. Most of the girls sleep, so I take a shower and I have a little privacy. And so I was washing my hair, and all of a sudden I felt a hand go up my back, like from the top of my butt up my back, and I yelled, "Stop it!" and I turned, and this girl said, "You like it?" And I said, "Get out of here!" And I started to scream, and she ran.
Okay. In the bathroom there, what was this? Which pod was this in?
This is in the annex.
In the annex. Okay. In the annex, are there guards positioned inside the area where you shower?
No.
Inside the area where you use the restroom?
No.
Okay. All right. The next thing I want to talk about is what transpired in October of, thank you, October of 2024, where you had said previously you were attacked. What were you doing? Where were you at, first of all, when that took place?
In October. So I was in the bathroom. It's 10:30 at night. I went in to brush my teeth.
Okay.
There are three sink stations in the bathroom. Each one has 4 sinks, and I was at the center station with my back to the door, and I'm a righty, so I was holding my toothbrush with my right hand, and I was balancing myself with my left hand on the sink. I was just brushing my teeth. That's all I was doing.
And what happened?
And someone came up behind me and pulled my left hand away from the sink and twisted my arm and like jerked it behind my back, like reaching up toward my neck.
Okay.
And
did it hurt?
Yeah, it hurt.
Okay. What happened?
It hurt. And I said, "What are you doing?" And she's, in the same breath that she did that with my arm, she said, "You're going to buy me commissary." I said, "I'm going to what?" And she said, "Unless you want those pretty white teeth knocked out of your mouth, you're going to buy me commissary." So I said, okay. And then she named a package that she wanted, and she's out. She was gone. She just that fast. That fast.
Okay. How bad would you, on a scale of 1 to 10, how bad would you rate the pain at the time that she did that to you?
Oh my God, it was a 10.
Okay.
I didn't know my arm could reach that far back.
Okay. And what did you do after she did that to you?
So, kind of stood there for a minute, and then I just thought, okay, I'm gonna go back to my bunk. And I went back to my bunk, and I got under the covers, and I cried. I just stayed under my covers. I didn't come out.
Okay. During your entire time in the annex, did this particular inmate remain confined in that area with you?
She was in the annex the whole time.
Okay. And I know that you don't want to talk about who did this to you, because why? Why don't you want to disclose who it was?
There's one thing I've learned since I'm there is you don't, and the word is snitch, you don't tell on anyone because you'll be sorry you did. And I've seen that. And so, I didn't even tell you for a while. I wasn't going to tell anybody. I didn't want to tell anybody. Because I didn't want, she's a big woman, and I was afraid of her.
Okay. Approximately how tall would you say she is compared to you?
She's over 6 feet, she's over 200 pounds. She's
Okay.
a very large woman.
Okay. Were you afraid of her?
Yeah.
Okay.
Yeah, I was after that.
Okay. And you said that she demanded that you were going to start getting her weekly commissary. Did you do that?
Yes.
Okay. Let me, can I have just one moment, Judge?
Go ahead.
Your Honor, in order to move this along a little more promptly, I've requested of the state, and they have no objection. At this time, I'm going to offer into evidence State's Exhibit number 3. I'm sorry, I said state by mistake. Defense Exhibit number 3, Defense Exhibit number 4, and Defense Exhibit number 5.
No objection, Ms. Dugan.
May I
They are
urge?
admitted. Thank you.
Ms. Adelson, prior to ordering commissary for this woman who attacked you, were you getting commissary for yourself?
So I have an account, and you can buy up to $40 a week of food, and so I use that account to buy food, but not what she wanted. She wanted packages.
Okay, let's make sure the court understands. When you say buy food, is there normal commissary through the jail where you were getting your commissary?
Yes.
Okay, and that's what you were spending $40 a week on for yourself?
Aramark, yes.
Okay, and what kind of items are you buying for yourself off of that?
I try to get some protein. I buy tuna fish with mayonnaise and
substitute meals, if you will?
Yes.
Okay, no noodles of any kind?
No.
Okay, all right. Now, is there a separate way that you can order commissary on the outside for inmates?
Yeah,
Okay.
I can't do that. It would have to be ordered from somebody. You have to ask somebody on the outside to place the order.
Okay, and when you referred to packages, is that the method that the woman who attacked you said she wanted you to get for her?
That's what she asked me to get her, yes.
Okay, and these packages cost about $40 each, is that correct?
$40 and then $10 for packaging or shipping, so it's $50 a package.
Okay, and during the course of your time in the annex, while you were still in the annex, on just about every week, did she continue to find you in the bathroom and demand what packages that you would get ordered for her?
Yes.
And
She must have been keeping an eye on me, but when I was in the bath, those are the only times she would approach me is in the bathroom, and she would tell me what she wanted for that week.
And did you make those orders through your husband?
I called my husband. I didn't tell him what happened. I just called him and said, honey, I want some extra food. Would you mind ordering some packages for me? And he said, sure, honey. And he did.
And he did that. And at the time that your normal canteen or commissary would be delivered, is that when the extra packages would be delivered as well?
Yes, all at the same time.
Okay, and in the course of things, you would go pick up your canteen and then her extra packages, is that
Yes,
right?
yes.
And where did you keep her items when you got back to the annex?
So it was, you have to carry your bin up, and they put the package, they open up a plastic bag and they loosely put all the stuff in the bin. So it was all in a bin that I would take back and put under my bed.
Okay, and did you keep her eye care packages separated from your canteen?
Yes.
Okay, and how is it that she would receive her packages? How did she get the food?
So she would send, I used to say her minions, she used to pick different girls to come over to me, and they would say, package up 4 soups and 3 bags of chips. And the first time I didn't know what she wanted me to do, and she said, it's for, and she'd mention her name. And I said, well, how am I supposed to do that? She said, just put it in your shirt, I'll meet you in the bathroom. So I would load these things in the top of my shirt, and I would hold the bottom of my shirt like this so that nothing would fall out, and I'd go to the bathroom, and then somebody would follow me in there, and she would take it out, transfer it into her shirt, and walk away.
And that continued from the time that she first yanked your arm behind your back in October all the way until you were put into protective custody, is that right?
Yes.
Okay, when you got into protective custody, in fact, did you receive your last packages for her?
So the last package came, I was put into protective custody on a Monday, and Tuesday, the commissary came with those packages and brought them to me.
Okay, and do you have that extra food in your protective custody room now?
They're sitting there. I don't eat that stuff, so it's all sitting on top of my bunk.
It's made up of noodles and chips and things of that nature. Is that correct?
That's correct.
Okay, all right. I want to talk briefly about your time in protective custody. How big is the room that you're in?
6 by 9.
Okay, and are you in this room by yourself?
Yes.
And is the door, with the exception of when they allow you to come out, is the door kept closed all of the time?
Yeah, it's supposed to be kept closed.
Okay, all right, and you're given, I'm kind of leading here, Judge, to try and get us through this, but you're allowed to come out of that room 1 hour per day on Mondays, Wednesdays, and Fridays, is that correct?
That's correct.
And on Tuesdays and Thursdays, you get to come out for 20 minutes, is that
20
right?
minutes.
Okay, and on the weekends, you don't get to come
Not
out?
at all.
Okay, make sure you don't talk over me, okay?
I'm sorry.
That's okay, we're talking over each other.
Okay, I'm sorry.
So Saturday and Sunday, you don't come out at all. During your hour 3 days a week and your 20 minutes 2 days a week, is that when you are given the opportunity to take a shower?
Yes.
If you have time to walk, that's when you walk?
So on an hour day, I'll walk for 40 minutes or about, and then I'll take my shower at the end of that, so I get my shower in.
Okay, and laundry also, that's what you use that
All
time
of that,
for?
yes.
Other than that, you're locked inside that room?
Yes, I am.
Okay, now, it was your understanding when you were put into protective custody that there's not ever supposed to be anybody out around you, is that right?
That's what I was told.
Okay, but protective custody is actually attached to a pod, is it not?
Yes.
And what pod is that?
M-pod, like Mary.
Okay. At some point, did you learn that this individual who attacked you was also, at least for some period of time, in that same area?
I'm not sure where she was. She might have been.
Okay.
I didn't see her.
You didn't see her?
I
Okay.
heard that she was there, but I didn't see her.
Okay. Now, you have testified earlier that different guards have kind of different rules that they follow inside the jail. Is that fair to say?
That's fair to say.
Okay. During the time that you've been in protective custody, when you were told you should not be around anyone else in the pod or otherwise, have there been times when guards would have you around other inmates?
Yes.
Okay. In fact, was there an occasion where another girl came and knocked on your door wanting you to give her food?
Mm-hmm. Yes.
Yes, okay. And what happened when you said you would give her food?
I said I have all that extra food. I don't mind giving it to people.
Okay. And so how were you going to give it to her?
Well, that's what I said to her. How am I going to get this to you? And so she gave the guard a high sign, and the guard buzzed the door open, and it was her and a friend of hers, the two of them, and they'd only stepped in my room like a foot, came in, and I gave them some soups.
Okay. Is that the only time that you've been around other people since you've been put in protective custody, or have there been other situations?
There have been other times. Like yesterday, the officer buzzed my door, so I guess there was something she wanted me to do, so I opened my door, and I came out, and there were maybe, I don't know, half a dozen girls watching TV. I walked past them, and I asked the officer, "What did you want?" And she said, "Oh, I'm sorry, Miss Adelson, I didn't mean to buzz you. Just go back to your room." I said, "Okay." So I turned around and went back.
Okay. We have to move along a little bit faster here. So one of the things that's been a big issue for you is lack of sleep. So we're going to just kind of go through this quickly for the court. But you testified previously that the nighttime medications come between 11:30 p.m. and 1:30 or 2 a.m. Is that correct?
Yes.
Okay. And part of the nighttime medications that you get, is there something in there to assist you to go to sleep?
Yes.
Okay. And then you get the medication. About how long after that is it before you can go to sleep?
From the time I get it, probably a half hour.
Okay. All right. And what time are you woken up for breakfast?
Between 3 and 3:30. Okay. Last night was 3:10. Just within that half-hour range is when it comes.
Okay. And once you're woken up for breakfast, are you capable of going back to sleep?
No.
Have you tried to go back to sleep?
Oh, my God. Yes, I try.
So that block of time that you get from the time you fall asleep after your night meds until you're woken up for breakfast, that's the only sleep that you're getting while you're incarcerated?
That's it.
How has that affected you?
So, listen, I know older people don't need as much sleep as younger people, but I need more than 2 hours a night. I need more than a good night is 3. One night I had 3.5 hours. It's not enough sleep to stay focused. I mean, I feel like I'm foggy sometimes because I'm sleepy, I'm tired, and I can't go to sleep. They've got people screaming and yelling.
All right, the live trial is kicked in, so we're going to bounce over to that. We'll come back to this, though, don't worry, because we still have about another half hour to go of this, at least a half an hour. So I am going to just pause this for now because it seems like people want to leave. All right, so we will leave. Just give me a moment. Let's go over to the live.
State versus Donna.
You may approach.
You may. Porsche, I know we went over this before. Was there anything that you need to raise as to the score sheet?
No, you're. Hopefully at 3:30, so.
Let's go ahead and get started with the 2:30 docket. First, State versus Donna Adelson, 2023 CF 3226. Mrs. Adelson, can you hear me?
Yes, I can.
All right, we can hear you clearly in the courtroom as well. Your counsel or counsels are with me in the courtroom as well as the state. Mr. Zellman or Ms. Fulford, whoever would like to go first, or Ms. Dugan.
Your Honor, first thing I want to address, I think it was last week, the week before, Your Honor issued the order concerning the prior investigator. When we were first before the court in December, we were told that the defense would have the benefit of what already occurred. I certainly understand the conflict issues, but our client is being punished and prejudiced in her ability to defend herself, not based on her actions, but on the actions of her former attorneys. It's our understanding that one of the things that the investigator did was travel down to South Florida, take pictures, identify times of travel. We don't have those materials, and we're asking for an exception to the court's order to get those materials, not his reports that he generated from interviewing individuals.
The raw materials.
Just the photographs and those specific notes. And if we want to do it in process where Your Honor makes sure that that's all that's being transmitted to us, fine, but otherwise our client's going to have to go to the expense of hiring somebody to do that same exact task.
The problem with this, Mr. Zellman, is if in any way the conflict bleeds over, that compromises the trial itself. The whole point of stopping the trial, because of the conflict, was not to have to do this a second time. Your client did select who she wanted to represent her. There is a conflict issue tied up in that. At this point, untangling all that is ensnared by the conflict presents more issues. Does the state wish to be heard?
I would defer to your ruling since you did the in-camera review, Judge.
As to whether any raw materials that were obtained by the investigator could be used, I will give this additional consideration. However, any report that he has made that remains subject to the ruling, him assisting with the defense remains subject to the ruling. Other matters that you need to address, go ahead.
Yes, Your Honor. In December, you entered the order setting court proceeding dates and procedures.
Yes.
I've conferred with the state, and we have a few requests for changes in those.
Go ahead.
With respect to the discovery deadline, which is now set for Wednesday, April 30th of 2025, we would like the order to be amended, if Your Honor agrees, to say that deadline will remain. The exception would be if the parties agree to depositions outside of that date. We've had some problems with getting some depositions scheduled when everyone is available. We already have one set in May 14th, so we would like just the opportunity to hold depositions past April 30th if everyone is in agreement.
Ms. Dugan.
No objection.
Very well, the deadline will remain in place. As to whether this would affect any motions that would need to be heard, that would occur once the issue presents itself, but you may schedule the deposition if you need to.
Thank you, Judge. We also were requesting that because of the discovery issues, that we extend the pretrial motion filing deadline to May the 9th and to presenting the final witness and exhibit list to May the 13th. And the state had no objection to that either.
Ms. Dugan?
No objection.
Those dates then will be moved as requested by the parties.
Thank you, Judge.
Any other matters the defense needs to raise?
Your Honor, we had previously submitted a proposed order concerning the wealth evidence, and we had addressed it by email with your judicial assistant in the state. And
Your Honor indicated that we would address it here this morning. The purpose of submitting that is so that there is complete clarity on the court's ruling, that there's not an issue. We are not trying to get into a situation where we're having to seek a mistrial.
As to that, I reviewed the original order and also what was proposed. They didn't exactly coincide. Is there something in particular that you believe needs to be clarified based from the original order?
I don't think that there is. I think that there's a difference in opinion as to what the court's order meant.
I reviewed the transcript on that as well, and I believe as it went to the state presenting any evidence of motive, or specifically that Mrs. Adelson was somehow involved with the offer of money relating to the, I believe, relocation of the children, that evidence would be permitted as far as any general evidence concerning her money, such as what her net worth was on a particular date. That was not going to be presented, but again, as it relates to presenting evidence on motive, that would be presented. What is unclear about this?
I think that clears up the potential confusion, Your Honor.
All right. Ms. Dugan, do you need to be heard on this point?
No, sir.
We've already filed 2 additional motions in limine. There are at least 7 more that we are still working on, and we are hoping to get filed in the next few weeks. When we were here last, I had indicated that there was another motion to suppress. I had hoped to file previously, but given the depositions that are scheduled, I want to wait until after those, in the middle of April, to get that filed, just to solidify some of the testimony. So that will be filed before the end of April.
Right. As to the motion in limine concerning the use of the book for impeachment, are the parties capable of handling this matter today?
I'm not prepared for that.
We can, I believe that the state's stance is that much of that has already been heard before as well, but we could get with your assistant and set a time for that to be heard.
Go ahead, so that way that matter can be resolved somewhat quickly, I believe, compared to the other motions, but there should be, let me look at the calendar. Probably handle either a 30-minute or 45-minute motion on that, even this week, if all parties are capable of handling it. State defense.
Just looking at my calendar, Your Honor, it looks like I'd be available, I could make myself available almost anytime Thursday and anytime Friday.
Ms. Dugan.
That should work. Maybe Thursday afternoon we could set something. If I could get with Ms. Kappelman and we'll email Lynn this afternoon, would that be okay?
Contact Lynn to see what time on Thursday we can go ahead and address the issue.
Yes, sir.
Yes, sir.
Of the book.
Yes, sir. And then lastly, on the venue issue, we have the materials from our expert. I was hoping to file it last night, but I'm still finishing putting all of the materials together. We also have spoken with the state about their position on filing those materials under seal. That motion to file under seal and the proposed order is already done. I can submit those today when I get back to the office. And then the materials themselves, I'd like to say tonight, but realistically probably tomorrow.
Please file them as soon as you're capable. If there is no dispute from the state concerning whether it's under seal, you may do so.
Ms. Kappelman indicated yesterday that there was no objection from the state, so that portion's already resolved.
Very well. Do the parties need another case management before we get to the more substantive dates and the orders?
The state does not.
Your Honor, at this point, I don't think that we do. If something arises that we cannot work out amongst ourselves and we need to get court intervention, we will certainly contact your judicial assistant.
well, let me briefly look at the order that was previously set. We're setting all of the dates and deadlines. Looks like the pre-trial is already preset by order for 5/16 at 9 o'clock. That will be the next date in which the matter will be addressed outside of any other motions. Unless either party has anything further to address, we'll be in recess for this case.
No, sir. Thank you, Your Honor.
That is the conclusion of the hearing. Have a good afternoon, everyone. Let's move on with our other scheduled 2:30 matters. Captain,
we have State Court versus Camelot Williams and State Court.
All right, so that concludes that. That was really quick, but I'll go over real quick what they said. The client is being prejudiced by her former attorney, so an investigator went to South Florida, and the defense wants those photos and the notes. So if they don't get that, then the defense is going to have to repeat that entire process. So some of the next court dates I heard was May 9th was a filing deadline, and there was something else after that. May 13th, there was maybe discovery. Well, I guess I didn't quite catch that. But May 16th was going to be the next hearing. So so that's that. All right, let's go back to the other one. We still have about a half hour left of that one, so let me go back to that one. So we're going to come back over here.
But I need more than 2 hours a night.
She needs more than 2 hours a night sleep. Let's jump back into this.
I need more than a good night is 3. One night I had 3.5 hours. It's not enough sleep to stay focused. I mean, I feel like I'm foggy sometimes because I'm sleepy, I'm tired, and I can't go to sleep. They've got people screaming and yelling. They bang on the doors, they shake the doors. It sounds like a drum in there. It's horrible. So I can't sleep with all that noise going on.
Okay. Do you have legal documents that we have provided to you or prior counsel has provided to you that you need to review to assist in the preparation of your defense?
Say that to me again.
Sure. Do you keep legal documents with you that you're supposed to be reviewing to assist to prepare for your defense?
Sure. I've got two bins full of them.
Okay. Are you having difficulty completing the tasks that we're asking you to do because of your lack of sleep?
Yes.
Okay. All right. I want to talk to you for just a second. You're able to make calls to your lawyers off of your tablet, correct?
Yes.
And those are supposed to be attorney-client privilege calls, correct?
Yes.
Okay, and they're not recorded according to what's said on the recording when you make the call, is that right?
That's right. That's
okay.
Right.
During the time that you were in the annex, were you in a situation where you could be away from everybody so that you could make those calls without anyone hearing?
No, I had to make the calls under my blanket because you couldn't hear me. I certainly couldn't hear you. So I would go under my blanket with the tablet and I would call you that way.
That didn't keep the other inmates who were standing right next to you from hearing?
It is what it is.
Okay. Was there a time when you and I were speaking and when you pulled the cover back there was actually a guard there listening to your call?
Yes, there was.
Okay. And during the time that you and I are having conversations, do you also experience the same kind of problems with the phone that you had heard that Charlie had while talking to you, where the calls are dropped, etc.?
We've had it numerous times.
Okay. Are there times where we're not able to hear each other on the phone calls?
Yes.
Is there static on the phone calls?
It's static, and now you've been complaining because I have this shortness of breath, so you say I'm breathing very heavy, and it's hard to hear me.
Okay.
So it's difficult.
All right, let me ask you a few questions. We're requesting that His Honor allow you to be out on bond pending your trial so that you can assist in the preparation of your defense. If His Honor ordered that you reside here in Leon County and not leave Leon County until the conclusion of the trial, would you agree to do that?
Yes, of course.
If he placed you on an electronic monitor, would you agree to take that?
Yes.
Okay. If he required that you have a curfew from 7 o'clock at night until 7 o'clock in the morning, would you comply with the curfew?
I would do that.
Do you have the ability to do these things?
Yes.
Okay. You have the ability to get housing here in Tallahassee where you could live with your husband?
Sure.
Okay. And if he said that, you can leave outside of the curfew, you can leave to go meet with your lawyers, medical appointments if you need medical appointments, coming to court, those type of things, would you comply with those orders as well?
Yes, I'd be grateful just to get a night's sleep. It would be great.
Okay. If he ordered that you had to surrender your driver's license during the pendency from now until the end of the trial and not drive, would you agree to comply with that?
Yes, I would.
Have just one moment, please. Thought I had asked this, but I might not have. For the medical conditions that you have complained of during the time that you were speaking with the doctors and they said that they didn't give you the treatments that you were requesting, did they ever offer that they would have a doctor from the outside perform the treatment for you?
No.
I don't have anything further.
Stephen, cross-examination.
Yes, sir. All right, so the incident in the shower, after you let the inmate know that you did not like what she was doing by telling her to stop, did she ever try that again?
No.
And that inmate's no longer, or you didn't disclose the name of that inmate, but you did tell the investigator that that inmate is no longer in jail with you, right?
She's no longer there. She left shortly after that.
Okay. As far as the arm twist incident from October of 2024, you said you reported that in February of 2025?
Yes.
Okay. And you wouldn't give the name, you said you wouldn't give the name of her to the investigator either, okay?
No.
But you do know that if you would give her name, that instead of you being separated from the pod, she could be separated from you and you could be back with the general population.
Yeah, but she's not the only one that could hurt me. That's why I wouldn't do it. She had a half a dozen girls that came up to me.
Was there ever any physical violence by her or anyone she's friends with after that October 24 incident?
No, that was it, that day.
And by being in solitary confinement, does it give you an opportunity to have a quieter space where you can prepare for trial?
I guess it would be a quiet space if I could get some sleep and I would be able to concentrate on what I'm supposed to do. Yes, that would be helpful.
Do you also get in-person visits with your attorney in jail?
I do.
Okay, and when that happens, are you in a room alone with him or her or both?
Yes.
Okay.
Yes.
And y'all are able to have conversations then that are private?
Yes.
For the sciatic nerve, in December of 2024, were you offered a solumedrol, a steroid injection for that pain that you declined?
I am going to object to the use of the medical records by the state based on a prior objection.
Stephen, do you have an ability to show that these records were not a part of what was obtained by Investigator Newland that is still disputed?
No, these are part of what was obtained by Investigator Newland, but my understanding is that the defense would have opened the door to this by asking her about all of these times she was seen by medical staff and what basically was not done for her.
As to that, I will permit the witness to answer. You may answer, Ms. Adelson.
Could you ask me one more time?
Yes, ma'am. For the sciatic pain that radiates down your right leg, were you offered a solumedrol, a steroid injection, and then after that a medrol, so a steroid dose pack, that you declined until you were able to speak with your physician?
No, I told her that in the past I had gotten a steroid injection in my spine And she said, we don't do that. I could offer you, and it was a Medrol dose pack, I think.
A Medrol
I
injection.
could offer you that, but we don't do that. And having had sciatica twice in my lifetime, I know what's been done each time, and I know that worked. And so she said, we can't do that. We don't offer that. You would need to see a specialist for that.
Okay. I'm going to show you this page. You're looking at the encounter from December 13th, 2024 at 3:22 p.m. Does it say, offered patient a Medrol injection and then starting tomorrow a Medrol dose pack? Patient requested decline until she can speak with her physician.
I don't know what a Medrol injection, but she told me they don't give steroidal injections in the spine. She says we don't do that. And I don't recall her offering an injection. I do remember she said I could give you other medication. But I've been there. I've done that. I know what happens with sciatica, and I know what needs to be done. That's not going to be the answer.
For your arm and shoulder pain, isn't it true that you reported you had mild pain in your left arm and shoulder?
No, I heard that gentleman say that before. I couldn't believe it. I told her that I had severe burning pain down the outer part of my arm. I never used the word mild pain, so I don't know where they got that from, but that's not what I said.
Okay. I'm going to show you the encounter from February 3rd, 2025 at 2:29 p.m. Under musculoskeletal, does it say positive for left upper extremity limited ROM range of motion, comma, mild pain?
That's what it says, but that's not what I said. In no way is that pain mild.
And so that's just what the doctor would have written down, but you're saying that's not what you told the doctor or nurse?
I did, had that been given to me and I read it and I had to sign it, I would say I never said this. But I'm telling you, I never said mild pain.
Okay.
It's shooting hot pain down my arm.
For that injury, you did have an x-ray and they did go over that x-ray with you and let you know that there was no fracture or dislocation.
There was no fracture, that's what she told me. I didn't think it was a fracture. No.
Or dislocation of your shoulder or arm?
No, there's just pain.
And they also went over your chest x-ray results with you to let you know that your chest x-ray appeared clear?
Yes.
Okay. You ultimately received the Band-Aid and Neosporin for the cut on your elbow?
Yes, I got that on, I think it was Saturday. When did I get that? On Monday.
Okay, so within a day or two of the cut occurring?
Yes.
And you said that if you are given a bond, you will reside in Tallahassee, you will follow court orders, but when you were afraid of being arrested right after Charlie Adelson's trial, isn't it true that you hoped that you could get to the airport before you were arrested?
I wasn't afraid of being arrested.
What were you trying to get to the airport in time for? In that jail
My
cell?
husband and I were literally shocked and traumatized at what had happened to Charlie. And he said, we need to just get some peace. We need to catch our breath. We're going to go away somewhere. And I thought it was a good idea because I couldn't think straight. I really couldn't think straight. I was so upset, and so was he. And it was his idea. He said, sweetheart, let's go, just get away. We're going to just get away somewhere so we can have some time to think.
Okay, so your testimony is that you weren't trying to go to Vietnam because you wouldn't be able to be extradited from there.
So my husband actually had said, we've been to Vietnam before with friends. We were on vacation, and it really was like a place of peace. And so he said, if we go to a non-extradition country, then if the law enforcement decided that they wanted to arrest you or me, whatever, both, he said, then he said, we won't be sitting in a foreign prison waiting months to go back. We can buy a ticket and we can go home. And my understanding was that I could go home and I could turn myself in if that's what they wanted.
Okay. But you were hoping to make it out of America in time before you were arrested, right?
I wanted to get away. He wanted to get away. That's what we wanted to do. And it wasn't, we spoke to our attorneys. I asked them. They said there's no pending. We purposely called them to make sure it was legal to do it. And they said there's no, what were their words? There's no pending charges and there's no warrants. So you want to go, go. And so I thought you ask your attorneys and they tell you that. I'm going.
But Dan did tell you, as you say in the jail call, that knowing what they're thinking up there, I don't know if you'll make it out in time. I really don't. But that he said you might, or you might get to the airport and they'll stop you. It could happen.
That's what he said.
Right. So you went to the airport knowing that it could happen. They could stop you at the airport. You could end up being arrested.
Yeah, that's what Dan said.
Right. And when you were looking at places to go those couple of days after Charlie Adelson's trial, you were specifically looking, though, for countries that did not have extradition with the U.S.
For the reason I just told you.
Right. And the reason that you're saying that you were looking for countries with no extradition was so that you could get back faster in order to be arrested in the U.S.
No, that's not what I said. It's because, I don't know, maybe we watch too much TV or too many movies, but I've seen movies where people are stuck in like third world prisons and waiting and waiting and waiting. And my feeling was, this is not what we want to happen. If the state says they want us to come back, we'll buy a ticket, we'll come back on our own terms. We don't have to be sitting in a jail somewhere. We'll come back home and turn ourselves in.
Couldn't you have done that no matter what country you went to?
No.
No?
No.
You couldn't have found out that you had a warrant for your arrest and come back if there was an extradition
Well,
policy?
not if they would, I'm not in law enforcement, but it appears that they would notify law enforcement in that country and then they could hold you in a jail for God knows how long. And I didn't want that to happen. So he said, well, that's why we'll do it this way, honey. That way, if they do notify us, so we get a phone call from our attorney or from law enforcement, then we'll buy a ticket, we'll go home.
Okay.
And so it would have been on our terms. That was the point. That was the reason that he thought that was a good idea.
And your
Before you continue, Ms. Dugan, we are over time. If you please can get to your most pertinent questions.
Yes, sir. I guess your testimony ultimately, though, is that you were not trying to go to a country with no extradition because you were trying to avoid being held accountable for this charge. That's your testimony?
I didn't do this.
Okay.
Being held accountable for this is not what happened.
Being arrested for this case.
Being arrested?
Right. That was not what you were trying to avoid by trying to go to a non-extradition country.
We were trying to get our heads on straight and just breathe.
That's all I happened to.
Any redirect examination for Mrs. Adelson?
Just one question, Judge.
You may proceed.
The testimony was you were offered an x-ray. You were never offered an MRI for your shoulder, were you?
No.
Thank you.
You may step down, Mrs. Adelson. Deputy, please assist her to her seat. Does the defense have any other documents or evidence or witnesses that it intends to present?
I don't have any other witnesses that I want to present. We did file a request to take judicial notice of the motion and order in the Adam Frash case where a request was made in a charge of first-degree murder for a bond for Mr. Frash, and that was granted. Has Your Honor had an opportunity to review that?
I did. the records of the circuit court, they don't have to be judicially noticed. What the other judges have done in the past certainly are a matter of record. Procedurally, we are in a different posture than Dr. Frash was, than your client, but any argument that you believe is reasonable, you may make concerning it.
Okay, the only other thing I wanted to do, Your Honor, is as an officer of the court, I wanted to represent two things. We attempted to obtain a copy of a no-fly order because that letter was received after Mrs. Adelson was taken into custody, and the only response we were able to get was that there's not from the U.S. Department of Homeland Security Traveler Redress Inquiry Program, was that there's not an open dispute of a no-fly order, so I didn't want there to appear to be a misrepresentation by myself in the motion and us not being able to present anything to the court. That's as much as they would say in response to our request. And then finally, I was glad to see that Mr. Google here is present, and I'm sorry I don't remember he's under sheriff, I think now, Mr. Google, in charge of the jail, and I just wanted to represent to the court that I did inquire about outside care, and the reason I questioned the witness about additional care from other doctors is I did inquire as to whether we could have her taken to see other doctors to get treatment that she could not get in the jail, and Mr. Google did advise me that with a court order that could take place, but we were never advised that without a court order she was able to get medical treatment that she was requesting.
Ms. Dugan, you may respond to the bond motion and present any evidence you have concerning presumption of guilt evident or, proof of guilt evident or presumption rate. Go ahead.
I have two very quick witnesses as to the medical or to the security concerns. Just a second. State called Chelsea Wilson.
Probably going to take all of it, but you can collect it for now. Yeah. Please raise your right hand, ma'am. Do you swear or affirm the testimony you're about to provide will be the truth?
Yes, Your Honor.
You may take your seat. You may examine when you're ready.
Will you state your name and spell it, please?
Chelsea Wilson, CHELSEAWILSON.
And where do you work?
Leon County Sheriff's Office.
What do you do there?
Specifically, I am assigned as criminal investigations for the jail.
All right, did you investigate an incident reported by Donna Adelson in February of 2025?
Yes.
That occurred back in October of 2024?
Yes.
And was that the incident where she said that an inmate twisted her arm in the bathroom area and told her that she wanted the canteen?
Correct.
Okay. Is there any video footage in the area where that took place?
No, not in the bathroom.
Okay. Did she disclose to you the name of the inmate?
No.
Did she disclose whether the inmate had ever been violent again, or anyone that is somehow related to the inmate in custody as far as being a friend or family member?
My understanding was it was a one-time incident.
If she had disclosed the name of the inmate, what could be done to hopefully keep that situation from happening again?
Well, we knew the name of the inmate. We could take measures to make sure that they were not housed together, that they were not in, for example, classes together. I don't know if she's interested in classes, but measures could absolutely be taken to make sure that they were not able to have physical contact with each other for her safety.
If we don't know that inmate's identity, though, and we can't take her out of the area where Miss Adelson lives in the jail, is the only option then to take Miss Adelson out of the area and put her in an area where she cannot not be threatened again?
Unfortunately, yes.
And did you let her know that? And if so, how did she respond?
I did. During the investigation, trying to get the inmate's name who twisted her arm, I did explain to her that I would be able to, or we would be able to move her back into a pod where she's able to move around more, where she's able to be social, for example. And her response essentially was that she felt, although she's not able to move around much in protective custody, she felt safer there, and that it does give her a little bit more peace and quiet to review legal materials for her upcoming trial.
That's all I have. Thank you.
Cross-examination.
I don't have anything.
You may step down.
Thank you, Your Honor. State calls Bobby Collins.
As far as the writing numbers, that might be a website, but that's fine. Please raise your right hand, sir. Do you swear or affirm the testimony you're about to give today will be the truth?
Yes, I do.
You may take your seat. You may examine when you're ready.
Will you state your name and spell it for us, please?
Lieutenant Robert Collins, ROBERT, COLLINS.
Thank you. And can you tell us where you work and what you do there?
I'm assigned at the detention. I oversee the classification unit.
Okay. How does the jail, the Leon County Detention Facility, handle when inmates are pressuring or threatening other inmates to buy them food from canteen?
Well, we interview the inmate, we gather information, providing what information that they give us. We will separate them out of harm's way and place the inmate separation, possibly follow up with incident reports or disciplinary reports.
Okay. And is there always an officer in every pod that an inmate can report an incident to, whether it be a security issue or a medical issue?
Yes, at all times.
Okay. Have there been any allegations made to the officers at Leon County Jail by Donna Adelson about any type of financial shakedown or threat in exchange for canteen, aside from the one made this month regarding the arm twist in exchange for canteen?
Not that I'm aware of. I only reviewed 2 incidents reports from February 3rd.
Okay, those were the ones made this month on February 3rd?
That is correct.
Okay, and those are the incidents that the defense cited in their motion?
Correct.
Okay, that's it, thank you.
Cross-examination.
I don't have anything. Thank you.
You may step down, Lieutenant. Thank you. Stugan, do you have any evidence that you wish to enter pertaining to the Arthur aspect of this?
I do, Judge. At this time, I'd move, and I'll just go through all of them at once. State's Exhibit 1, which is the probable cause affidavit for Donna Adelson. State's Composite 2, which are the transcripts from Charlie Adelson's trial, which Your Honor presided over. State's Exhibit 3, which are a PDF of slides from Chris Corbett's PowerPoint presentation that only feature the analysis of Donna Adelson's travel the night of July 18th, 2014. The open line jail call that we've referred to today from November 7th, and the transcript of, that's State's 4, the transcript of that call, which is State's 5. State's Exhibit 6, which is a chat with a Vietnam visa on WhatsApp by Donna Adelson. State's Exhibit 7, which are excerpts from WhatsApp, conversation between Charlie Adelson and Donna Adelson. And then finally, State's Exhibit 8, which is a letter from the Markel family to the court, which defense has reviewed regarding their wishes for bond.
Concerning the state's exhibits, does the defense have any objection or anything to raise?
With respect to State's Exhibits 4 and 5, renew our objection, as we believe the call should be suppressed, as well as the excerpt from the call and the transcript. So we would object on that basis.
As it relates to whether the court will consider Exhibits 4 and 5 that will be tied to the order on suppression as to all other matters, is there any objection?
No, Judge.
Court reserves whether Exhibits 4 and 5, and I believe which other ones were you contesting?
Just 4 and 5.
4 and 5 will be admitted. All other exhibits offered by the state for the purposes of Arthur and bond will be admitted at this time. Ms. Dugan, do you have all of these available?
I do.
Can you please can approach?
Okay, and then 1 through 7 are all on flash drive.
And the state's provided us, I downloaded a copy of the thumb drive earlier, so we have those as well.
All right, Ms. Dugan, you may make your final argument concerning the Arthur standard and also bond.
Yes, sir. I guess I'll go with Arthur's standard first. As to State's Exhibit 2, the transcripts from Charlie Adelson's trial, I think that the parts of these trial that were most relevant to whether we've met the standard in Donna Adelson's case are the emails that show Donna Adelson's motivation to commit the crime when she voices her hatred towards Dan Markel, strategizes ways to get Wendi Adelson and her sons to live in South Florida. The thousands of dollars worth of checks we saw in that trial that were written to Magbanwa, signed by Donna Adelson when Magbanwa never worked for the family in any capacity. Magbanwa's testimony that Charlie Adelson was about her being the middleman between Charlie Adelson and the hitman for this murder, and how on July 18th, 2014, which was the night of the murder, that Charlie gave her money at his home, which she then delivered to the hitman. Magbanwa saying that she learned that night, the night of July 18th, that Charlie Adelson and his parents had just been at the home. It was her understanding that Donna Adelson had washed the money and the money was damp. For the State's Exhibit 3, which is the travel analysis, basically these slides show that Donna Adelson and Harvey Adelson's travel from their home in Miami to Orlando on the night of July 18th, 2014. At a certain point, Donna Adelson texts Charlie Adelson, "I'm outside your house," or "outside your house." Charlie Adelson then responds a little while later with 10 minutes. Cell tower analysis shows that Charlie Adelson is inconsistent with his house 10 minutes later, and when you look at the time it took for Donna Adelson to travel from the area of Charlie Adelson's home to the next point with location data for her north of Charlie Adelson's home, it shows that it should be about a 45-minute trip, but it shows that it took her 1 hour and 54 minutes. That shows there was 1 hour and 9 minutes unaccounted for during the time when she would have been waiting for Charlie Adelson at his house and could have stayed there for about half an hour once he arrived. And that could be consistent with her taking some of the money to Charlie Adelson's home, as Magbanwa describes. State's Exhibit 4 is the open line jail call we've already heard today. On page 8, she does say, after speaking with Dan this morning, after knowing what they're thinking up there, I don't know if we'll make it out in time, I really don't, but Dan says you make it to the airport or they may stop you. It could happen, but it's worth a try. She then says on page 16 that they've looked it up over and over because things change, whether there's extradition from Vietnam. They could go to Korea or China because there's no extradition there. We are looking for places where there's no extradition. State's Exhibit 6, which is the chat with Vietnam Visa on WhatsApp. In that first message, that service tells Donna Adelson that all of the messages are encrypted and no one can read them. She began on this WhatsApp trying to get the visas during the afternoon of November 7th. That's less than 24 hours after the trial transcripts and State Composite 2 reflect that there was a jury verdict in Charlie Adelson's trial. Donna Adelson says in that conversation that she needs an emergency fast-track visa for her and her husband. When given the option of 30 or 90-day visa, she chooses 90, unless she can only do 30, and in that case, she'll do it and just extend it. She then sends passport pictures and pays for the visas. Several days later, she says to the service that she's getting nervous because she hasn't received the visas yet, and she's typing all of that in all caps. She says her flight is booked at that point, which is the one-way trip to Vietnam with the layover in Dubai. That's within days of Charlie Adelson's verdict. The chat shows then that she got the visa just in time, I think the day before the flight, and then she ended up being arrested on the jetway in Miami right before she boarded the one-way trip to Vietnam. We also have the excerpts from the WhatsApp with Charlie Adelson, State's Exhibit 7. This is a conversation that the court has seen before. We've had a motion hearing about it, I believe, where basically we were able to get these messages in 2023 when Donna Adelson was arrested and we seized her cell phone. This is from the WhatsApp with Charlie Adelson on her phone. These are WhatsApp messages, though, that occurred in August of 2016. And there's a conversation between Charlie Adelson and Donna Adelson where Charlie Adelson is basically workshopping ideas that maybe the killer was a coke dealer and that Danny was just buying drugs from him. And in there, they don't mention anything about extortion, which ended up being Charlie Adelson's defense at trial, that he didn't intend for this to happen, that he was extorted, and that he didn't do this. And finally, the letter from the Markel family. Given the totality of the evidence in this case, the state does meet the burden under Arthur. The state has met its burden for every defendant who has been charged in this case and had an Arthur hearing. They have all been held in custody until trial. And none of them tried to flee to a non-extraditable country to avoid being charged before arrest. If court somehow believes the state falls short, though, the defendant should still be held no bond because she is absolutely a flight risk, given her past actions. More so now than ever, now that she has actually been charged. What we saw her talking about on the jail call and doing in the visa chat and going to the airport for and being arrested there, that was all before she was even arrested, when she just knew that the charges may be coming. Now she has been charged, she is facing life in prison, so I think she's more of a flight risk than ever when you consider a totality of all of that information. As to the bond argument, we heard from, the Mike Hayden, who's the medical administration. All of the defendant's complaints have been evaluated. Medical staff has treated them. She's been able to see a doctor in a day or two. That is faster than most of us who are out of custody could see our doctors. She was given Band-Aid and Neosporin for the cut on her arm when she bumped into the laundry machine. Sometimes accidents like that happen, and that could also happen to her out of custody as well as it could happen to her in custody, to bump into something and get a cut. We heard about her breathing and pain issues. Doctors ordered x-rays to make sure nothing more was going on, and the x-rays were negative. Medical staff can provide treatment for any inmate's medical needs, whether it be on-site or them having to go to a hospital, but they also need evidence of what's wrong and what needs to be treated beyond the inmate just saying that they hurt. And to see a specialist, there does need to be a necessity. If there's a necessity, Leon County Jail will recognize that and make the necessary referrals. Ms. Adelson has complained about the jail being too loud. The food is not good, but she is in jail. It's not the Four Seasons. All of her necessities are being met, and she should bring, and should she bring a medical necessity to the staff's attention, they will continue being met. As far as security is concerned, she wouldn't provide the identity of the inmate that caused the concern. If she would, then she could remain where she is while the other inmate is taken out. However, because she won't disclose, the only option right now is her being in protective custody. But as she did tell the investigator, that does, even though I'm sure it's not very exciting and it has its downsides, it is a quiet place where she can prepare more for trial. And so she's saying that she prefers that right now. The state asked that she continue to be held no bond at Leon County Jail because she's safe there and it will guarantee her presence at trial.
Final argument from the defense.
With respect to Arthur and every other defendant prior to Ms. Adelson being held and Arthur being met, Ms. Adelson isn't the prior folks. She's not the ones who showed up at Mr. Markel's residence with a firearm who planned to kill him and then did shoot him at very close range and take his life. She's not them. There's proof there. They can meet their burden there, clearly. That's not what Mrs. Adelson is even alleged to have done. In this case, did they hold Charlie? Yes, they did. They met his burden too. The proof against Charlie is very different. I'm representing, Your Honor, a woman who stands before this court, and the argument out of the state's mouth literally is what I put in my motion. She said some bad things about her future ex-son-in-law prior to a divorce being granted. She cut some paychecks out of Charlie Adelson's business, and it was her job to cut the paychecks, and at his instruction, she cut paychecks to Catherine Magbanawah. When her daughter called to say that her soon-to-be or her ex-husband had been shot and killed, Ms. Adelson got in her car with her husband and drove from Miami to Tallahassee, and they're elderly folks, and that's a part of the record. It's a natural course of travel from Miami up to Tallahassee to go through the Orlando area. The state actually said in its argument that the time that lapsed between when they show the cell phone records of Donna Adelson and being near Charlie Adelson's house, and then when Charlie says he's going to get back, could be consistent with Mrs. Adelson stopping there and giving them this alleged pre-washed money. Could be consistent is not the Arthur standard. It's proof evident, presumption great. And they simply...
Proof evident or presumption.
Or presumption great. And they don't have that in this case, Judge. What they have is the strongest, could be consistent with. Their entire case against Mrs. Adelson is speculation. The problem here is not one problem, that health issues are not being taken care of, or sleep is being deprived, or, you know, she's not getting the food that she likes. Nobody's complaining about the fact that she's not getting food that she doesn't like. She's gained a third of her body weight. They can't protect her in the jail. They've testified themselves. There are no cameras inside the area where they use the restroom, the area where they take the shower, where these washing machines are. There are no guards in there. There's no video in there. So if she disclosed the name, which she's willing to do in camera to the court with nobody else present because she knows she's going to be retaliated against, they can't protect her from retaliation. If they put her back in the annex and some girlfriends or friends of this woman that she rats out finds out that she's back in there, they can take her down in the bathroom, and the guards who are sitting behind a glass being protected themselves aren't even going to know it's happening until it's too late. So providing the name doesn't do that.
Before you go on, Ms. Fulford, as to the sheriff's role in this, he has a constitutional responsibility to all inmates. Also, your client has the ability to pursue a writ of mandamus if the sheriff will not fulfill his obligations. Is there a reason this has not been pursued if the situation is, as you allege through your motion and testimony?
Because that's not the only issue we have, Judge, which is what I was getting to. What we have before us is a woman who's 75 years old. She's elderly. She has health issues that aren't being addressed, but there's more. She's not getting any sleep. She's given medication between 11:30 and 1:30 at night, maybe getting to sleep by 2 o'clock in the morning, waking back up at 3 or 3:30 in the morning. We're not asking that she get special treatment. She's on trial for her life in a town where everybody believes she's guilty. That for 10 years, it's been the same story, that the mafia mother has planned out this homicide and had Dan Markel killed on this evidence that could be consistent with, and that's not what we have. We can't prepare her for trial under these circumstances. Can we go and visit with her at the jail? Yes, we can. Do we have contact visits with her where we can prepare? Yes, we do. But we can't be up there 5 days a week. We can't be up there 7 days a week. We can't be there for lengthy hours. We're not the only ones who are requesting that time. When we got the records from the medical records from the state last week, there was one time that the jail was able to squeeze us in for 1 hour to go through the medical records with her. Over 300 pages of medical records. And we had other things to do in that time for us to meet with her. And I'm not criticizing the sheriff's office, and I'm not criticizing the jail. The circumstances are what the circumstances are. But if she remains in the jail, we simply cannot have her prepared to testify and assist with preparation of her defense. I cannot have an attorney-client privilege call with her there. It's the most frustrating thing in the world, this phone system that they have. They say that it's not recorded, and we get cut off. It says we're making third-party calls. Neither one of us has made a move. Nothing's happening. We get cut off in the middle of the calls. She has this labored breathing. If they can't find anything in the x-rays, I'm certainly not a doctor. I don't know why she's got it, but I have to start yelling to have her to stop talking because she's breathing so loud, I can't hear a thing she's even saying. She did not flee. She did not flee prosecution. She was told, and witnesses for her were told, there was no prosecution. There was no warrant for her arrest. That it was perfectly fine, and the state knows this. Their own investigator told a family friend, there's no warrant. They can travel. They didn't attempt to flee being prosecuted. They were told there was no warrant.
Is this
for
part of the
arrest.
evidence that's in the record, or you're just making argument generally about this?
I'm making argument generally at this point, Judge, but the state knows it. If they're going to claim that she was actually fleeing, they know better. They know that their own office said it was okay for her to travel. And where did she get to? Absolutely nowhere. And they have absolutely zero evidence to rebut her testimony that she was not going to flee prosecution. She was just going to get away to clear her head. In fact, she thought she wasn't being charged. And that's all the evidence that she had. Now, if we were coming before you and she had actually fled and someone had to bring her back, I wouldn't put my name on a motion saying, give us a bond. But this isn't the first time that people have gotten a bond. Even people who fail to appear ultimately get bonds sometimes. Your Honor's aware of that. That does take place. People who violate their probation can get put back out while their hearing is pending for that violation of probation. If she has already surrendered her passport, she doesn't have a visa, she agrees not to drive, an electronic monitor is placed on her, she resides in Leon County, has to check in with pretrial as many times as you say she has to check in, can only leave for limited purposes, she's not going anywhere. And we're not asking, let's let her go back to Miami where she has an international airport that she can hop on and be gone before anybody knows that her bracelet is going off. We're asking that she be held right here, that she be court-ordered to stay here with a monitor on, be allowed to be away from that home, to go to doctor's visits, get any medical treatment that she needs, come to court, be with her lawyers, and prepare her trial. We're not asking for a fancy hotel or anything else. And quite frankly, that's a little bit insulting considering the health conditions that she has to suggest that she's looking to be put up somewhere. The one thing the state fails to remember is she's presumed innocent. No, the Leon County Jail is not a Four Seasons hotel, but she's not supposed to be punished yet, right? She hasn't been convicted of anything.
There is a difference between pretrial detention
and she's being punished at this point. When you take not one of these things, but all of these things together, she doesn't stand a chance of being actually ready to testify for trial. That cannot take place under the conditions that she's facing. She's in extreme pain. She's not getting any sleep. Her diet is garbage. It's just not going to happen, Judge. And you know, if we were asking for something lenient, I could see the state's opposition. But we're not. We're asking for you to hold her outside of the jail in the most stringent conditions she could possibly be monitored, just to allow her to be with her attorneys, get her doctor's appointments, and get ready for the trial that her entire life depends upon. And I would argue the state has not met its burden. Thank you.
Very well. I will review the admitted exhibits before making a ruling. We are in recess. This concludes the hearings. You may take Mrs. Adelson downstairs.
Thank you, Your Honor.
Thank you, Judge. May I use this? You don't want that, no. Thank you. You think I need to copy it too, because you can see through it?
Bailiffs, please assist her out.
Okay.
Everyone else can step out of the courtroom at this point. We are done.
Yeah, that'd be great. Quicker if she does it, that's
All right, I got a treat for you guys. So I looked up Tallahassee. I thought it says it's an international airport, but I don't see any flights that are actually going international. They're just Atlanta, Charlotte, Dallas, Miami, Fort Lauderdale. So even though it says it's an international airport, it actually does not, or at least it doesn't seem like it travels. All right, I got a treat for you. We're not done with you yet. Class is not dismissed just yet. All right, got a treat for you. Hold tight, hold tight. Give me a second. Because we've heard so much about it, let's watch it. This is going to be Donna's arrest. All right, Donna Adelson's arrest at the Miami International Airport.
this is evidence. Evidence. She's under arrest. I have to go with you. I have to go. Let me help you out. No, I have to stay. Please don't do this. You need to grab the bags. Take the bags. Yeah. And you need to wait outside. Okay.
My husband's almost 80 years old. He can't come with me?
Please, can I help? No, you can't join me there. Oh, don't do this, please.
Please.
Oh,
Someone's got to help him get home. This is terrible. You can't do this. This is insane.
Is that okay with you? Please, give me that with handcuffs on. She's not going anywhere. Please. Please. Do you have anything in your pocket?
No, no.
Do you have anything of value in you?
No, I
Does she have a necklace on? You can take it off. I'll take it. Yeah, take it off. Yeah. And the earrings. And the earrings, the rings, take everything. You give it to your husband. Because once you arrive at county jail, they're going to make you remove all that.
Can I call my attorney?
You came, you have a passport ready?
Where am I going?
Open your finger.
Where am I going?
You're going to the Dade County jail. Dade County jail. Broward County, right? No, this is right here, the one on... Where are you going? I'm sorry, remove your earrings? How it happened?
1 minute.
You're making a mistake. It's not a mistake. It's two mistakes. Can you take it off, please, Donna? I don't want to hurt her. Please.
Just a minute. Just a minute.
Please.
It's getting there. Hold on. Listen to me.
Yeah. I'll call.
Get in an Uber. Go home.
I will.
Take
I will.
it easy.
I will.
All right?
Yes.
Here.
If there's anything else in her person that she wants to...
Oh, but it's coming, sweetheart. It's coming. Just a second.
Do you have her driver's license somewhere in chance? I'm sorry? Her driver's
It's in my
Yeah.
It's in my purse.
Yeah. Yeah, then you could give her a try. Sir, do you need her passport? Or can I give it to the husband? The passport, can I give it to the
What's on?
Where is it?
It's in the blue and white. It's in the blue and white.
Yeah, but I'm going to get your driver's license for it. Yeah. The license, the address on your license is correct?
Yes.
She needs all her details. When she goes to the jail, they work with the hospital.
They're all in here, though.
Yes, but they work. If I take them here, what would happen is when you go there, they toss them out. So when you go to there, you will meet the nurse and the doctor, and then they'll work in conjunction with the hospital to get you whatever you need.
Yeah, but I don't have a list with me. I know what's in
driver's license? Yes.
I have a.
Is it multiple or is just one or two?
No, there's a bag of medication in here. Is that what you're asking me?
She can take medication. No, I know. I was just trying to find out if it was like one or two. Yeah, if it was one or two, then she maybe could take the name down. Do you need anything else from her?
Can I ask you something? Can someone just get my husband outside?
I'll get him. The gentleman here will assist him in any way.
I'll be okay. I have the ring. Hold on.
Let me have the ring, please. No, I'll
That's crazy.
Okay.
All right, so I don't have the meds, honey. They're all in here.
Give me 1 moment, please. Hold the body. 1 moment.
Thank you.
case number, Kiki? No. Okay. All right. Yeah. I'm running 06 from now, from here, and then I'll get the case number for the video.
Okay, we want to thank Morgan & Morgan for sponsoring this body cam video. I mean, I think it's pretty clear from the body cams that we cover that it's not always safe.
Let me leave the camera. The address on the license is good? Huh? The address on the bring up the window because it's raining. It's raining a lot, yeah? Yeah, it's been raining. Okay, brother. Thank you, man. Alrighty. I'll see you. Airport 3502. Change my QTH to Warren, transporting a white female. Ready for starting?
Shifted.
6003.
20.
Gonna roll up the windows. It's raining once we exit, okay? Let me lock the door.
Just push my glasses up a little on my nose.
Absolutely. Like that?
Oh,
Okay?
thank you.
No, you're welcome. I'm gonna go to that office right there on the corner. Let me get the door for you. Thank you. How you doing? Just have a seat over there. Yes, ma'am. Yes, please. We turn around a little bit this way, so it's protocol that we need to follow, you know? Rules and regulations. Ready? Whatever. Take your time, no rush. Careful with your head. And we're gonna go through that door over in the corner. Show me a right wheel, okay? Ready for that? 6014. That's how I see it. Oh, you know why?
It's a little bit.
Yeah. That's why. Let's stand over there just in case it starts raining. Hello. How you doing, boss? Okay. Hold on for me.
All right. I got one more thing for you. Just one more. All right, check this out.
Trent, thank you. Also,
Got one more thing for you. All right, so that was Donna's arrest on the 11th. And yes, she was talking to her estate attorney on the 7th or the 8th. November 7th, that's when she had the phone call. She was in the living room. Yeah, her estate attorney was there November 7th. She may have talked to them afterwards. I don't know. All right, so one more thing. One more thing. Here we go.
before you knew, the mother of a South Florida dentist convicted in a murder for hire killing appeared in court today following her arrest.
Donna Adelson was taken into custody at Miami International Airport last night. Local 10 News reporter Syra Anwar is live outside the jail in West Miami-Dade.
And Syra, I know you have some new details on the arrest and the charges she's now facing.
That's right, Janice and Christy. Just 1 week after her son was convicted for murder, Donna Adelson is now behind bars. A state attorney says she was arrested at the airport while she was trying to fly to Vietnam, possibly to evade extradition. A grandmother behind bars this morning in Miami-Dade County. Donna Adelson appearing before a bond judge after she was arrested and charged with murder, conspiracy, and solicitation out of Leon County.
We, the jury, find as follows as to count 1 of the indictment, first-degree murder.
Last week, a jury in Tallahassee convicted Donna's son, Broward periodontist Charlie Adelson, in the murder-for-hire death of his ex-brother-in-law, Florida State professor Steve Markel.
Evidence has shown that on July 18, 2014, this brilliant man was gunned down in broad daylight in the driveway of his own home.
His conviction stated he hired hitmen to kill Markel in 2014, while Markel was in a bitter custody battle with Adelson's sister, Wendi. In Charlie's trial, the prosecution continuously brought up Wendi and Donna's names and evidence during the length of the trial, indicating the two women as co-conspirators, hinting that they too would face charges in Markel's death.
So who did it appear had a motive to want Dan Markel dead? His own family.
Markel was shot in the head twice on July 18th of 2014 in his parked car just outside of his home in Tallahassee. Charlie Adelson was convicted of first-degree murder along with other charges related to Markel's death. 3 other individuals convicted in the plot to kill Markel are already serving sentences, including Charlie Adelson's ex-girlfriend Catherine Magbanwa, who confessed to connecting Charlie Adelson to the 2 other hitmen. And now we have an excerpt from Donna Adelson's arrest document that says, quote, jail calls from after Charles Adelson's guilty verdict include multiple calls in which Donna Adelson is telling Charles she is getting things in order, creating trusts, and making sure her grandchildren are taken care of. Donna discusses plans for a suicide, but also discusses plans to flee to a non-extradition country. So back out here live again, Donna Adelson was arrested at the airport. That state attorney says she was trying to get to Vietnam. Now, as far as extradition, since she is in state here, Leon County authorities now have 15 days to come here and pick her up from the correctional center here at TGK in Miami-Dade County. That is the very latest live here in West Miami-Dade. Syra Anwar, Local 10 News.
All right, so that concludes our Donna Adelson videos. Did Gordon? Hey, Gordon, you made it in. You're very, very late, but you're very, very handsome. I love it. All right, so yes, Judge Everett did deny her bond. He said he ruled against the defense, finding that Adelson clearly demonstrated an intent to flee when she tried to board a flight from Miami to Vietnam a week after her son Charlie was found guilty. Everett also said one of the primary considerations of setting bail, ensuring a defendant appears in court for trial, couldn't be met. So one of the primary considerations of setting bail could not be met. Everett goes on to say, one day after Charles Adelson was convicted of first degree and other crimes, the defendant discussed fleeing the countries without extradition to the United States. Everett wrote, that same day, defendant communicated with Vietnam Visa Indochina Sun Travel through what she believed was a secure communications application, WhatsApp, heard that name before, trying to acquire a fast-track emergency visa for Vietnam and wanted the fastest she could get it. Then Everett, in a separate order, also denied defense motion to suppress key evidence. Now, that was the phone call that we heard about and we saw. Judge Everett denied defense motion to suppress key evidence that he referenced in his decision to deny pretrial release, the jailhouse phone call in which Adelson talked about possibly fleeing the country. So, in the order denying bond, Everett said the Leon County Detention Facility was taking reasonable measures to address Adelson's concerns, including complaints about her health care behind bars and her ability to prepare for trial. She has undergone extensive trial preparation since her trial was continued last year through the present. Now, we heard all about her issues. She was talking about... she got attacked. She got attacked by a large woman while she was brushing her teeth. She got attacked in the showers. The shower incident, her arm twist incident. She said a half dozen girls came up to her. She also says that she's not getting sleep. That's affecting her ability to focus because she's not getting enough sleep. So that's affecting her ability to focus on her trial. It's been a busy day of Donna. All right. What are you guys talking about? Do you have any questions? Any questions, comments? Jerly Frew, yes. The washing machine jumped out at her, boo-hoo-hoo. And yet she's in line waiting for the med nurse. She says she's bleeding uncontrollably. She asked for a Band-Aid, but if you're bleeding uncontrollably, you're going to ask for more than just a Band-Aid. But Dwayne, after this, you must watch Mr. Tellis on Cross for the Laughs. She was 6 foot and 200 pounds. Those were Donna's words. 6 foot, 200 pounds. Kind of, reminds me of Oscar Solis. He was a big dude. Traveling Teresa, yes, he denied the phone call motion to suppress as well. Yep, I believe I just read that as well. Maybe I didn't highlight that as much, but yes. So yes, he denied both of those motions. So she's not getting bond, and that phone call to Charlie in which she says that he hung up and she was still talking. Those are both. She's not getting bond, and the phone call from Charlie is coming in. Hey, Rachel, Jack Fox did a really good analysis and potential deception in her testimony. You guys should watch it if you get a chance. All right. She's probably 6 foot, 200 pounds. That's what she said, Ola. That's what she said. She said she said that she was 6 foot, 200 pounds. Dan was attacked. Yep, in his driveway. He sat in his driveway, and the two, Sigfredo Garcia and I always remember Garcia's name. Who's the other guy's name? Shoot, I can never remember the other guy's name. Garcia and Sigfredo Garcia and
he was the king of Latin.
Always forget. Why can I never remember their names? Sigfredo Garcia.
Luis Rivera.
Rivera. Yeah. Brenda Meyer, thank you for sharing this. I enjoy watching your getting hand cut. No problem. Widespread panic. Yay, Judge Everett. I knew I liked that dude. Baca, right now it's set for June 3rd with May something for cutoff for discovery. Let me see. When's cutoff for discovery? May 30th is cutoff for discovery, which is, April 30th. So right now it's starting June 3rd. Right now they're starting June 3rd. Hey, Mr. T51, I got a free trip to Vietnam. I went on a 1-year plan with all expenses paid by Uncle Sam. Pretty cool. Green-eyed cat, yes, both motions were already decided. Remember, this was about 5 weeks ago. What we watched today was about 5 weeks ago. Julie Frew, Luis Rivera pled guilty. Sentence 9. Yeah, I always, for whatever reason, I remember Sigfredo Garcia. I don't know why I remember his name, but Luis Rivera. Yep, he was the other one. So, Tuto and Tato. That's true. That is so true. Good one. Mr. T51. Yeah, that was pretty cool. Julie Frew, he wasn't the pew person regarding Luis Rivera. Well, one of them drove. Was it Rivera drove and Garcia actually shot? Is that how it worked? I forget now. It's been such a long time. I'm sorry.
They shot the car. They went up a couple times.
Yeah, they went up twice.
Yep. And they shot the car. And then they did a bunch of coke and drugs.
All right. Let's see, what else you guys talking about? If you guys have any questions. What am I doing wrong? Did I do something wrong? I did. Very pure soul. Takes people's comments. What did I miss, guys? What did I miss? Truth is, I wouldn't mind going back to Vietnam. It's a really beautiful country. Oh, did you go there for the war? Is that what I missed? Sorry if I missed that. My bad. Oh, you went for Uncle Sam? Gotcha. Sorry to hear that. All right. Anything else before we call it a day? Tracy L. Was Donna present today at a hearing? She was not. Or if she was there via Zoom, I guess. I don't know. I did not see her in the courtroom. Did not see her in the courtroom. Oh, referring to the name switch? Oh, that's what I missed? Gotcha. All right. Sorry, Mr. T. Thank you for your service. Kerviel, is there any more Donna stuff to show to catch up? There might be. There might be, but I'm sure she's had, let's see. Yeah, there's always Donna stuff. Julie says Donna was there on Zoom. Please cover Linda Sturmer. Depends on when that is. I don't even know who that is, but we'll check into that, Julie. He had made the ruling. Let's see. This happened like 5 weeks ago, and he made the ruling. He made it like they said on a Monday or Tuesday or something. So I'm not sure of the exact times, Tracy, but today's hearing was just case management. It was about Kine is being prejudiced by her former attorney. Investigator went to South Florida, and defense wants those photos and notes. If they don't get that, the defense will have to repeat it. They talked about May 9th filing deadline, and May 16th is the next hearing. That's basically what today. That's what today was. OnlyFan. That's pretty much what it was. So, all right, guys, we're gonna call it. We're gonna call it. And thank you for joining us. Appreciate you guys. Let's see. Tomorrow is going to be. We're hoping that that New Jersey versus Higgins. That's where the guy who was driving drunk and he hit the two NHL hockey players, brothers. They were at their sister's wedding, and they got. Unfortunately, they died. So we're hoping that they stream that. So we're going to do that, and then we're going to pick back up on Karen. Oh, Morgan Geyser's tomorrow too?
There's a hearing that we can rewatch.
Okay. I thought we'd do that on Thursday. Anyway, we'll figure it out. So anyway, we have lots to watch. So definitely join us tomorrow. Thank you to Aaron. Thank you to our mods. Hope you guys have a good rest of your evening. Join us tomorrow. We're looking 9 a.m. is the New Jersey versus Higgins, so hopefully we'll have that. And if not, we'll pick up something else. There's plenty of crime out there. Don't worry. So thanks for joining us, and we'll see you later, guys. Bye.